is running in the list 168. But I filed a CRAN.
168.
Well, I filed a CRAN 2. Well, the CRAN has been filed, but it has been appearing under the heading. Well, appeal hearing, which is bail in connection with that.
168.
Dr. Chandra. I filed a CRAN.
No, Ratan Chandra De is appearing with Manik Chandra De.
And Manik Chandra De, I have not filed a CRAN. All the appellants are on bail. So far as Ratan Chandra De is concerned, CRAN 1 was disposed of by the coordinate bench, earlier coordinate bench in the month of April. With the liberty, if the appeal is not heard, you can pray for renewal your prayer.
I see.
For that reason, I filed CRAN. That is appearing in the list.
Who is your other side in that matter?
Sir, Aniruddha Vishwas, he has been intimated because with CRAN has been filed, then CRAN has been served, then it has been filed.
Only 167, 168 একসাথে ট্যাগ করা আছে ওইটা কি তুমি
And I think same.
ওই দুটোকে অ্যাপ্লিকেশন ফর্ম বেলে রেখে দিই
Billing collection with
হ্যাঁ সেইটাই রাইট তাহলে তুমি শুধু ওই ম্যাটারটা তুলো না দুটো ম্যাটারই 167 আর 168 তুলে বেল ইন কানেকশন কাটিয়ে inform your others.
My lord, may I be permitted one matter, my lord? My lord, this is also bail in connection with appeal, my lord. Suspension of sentence, my lord.
When was it last heard?
My lord, there was, my lord, 2-3 occasion bail was rejected, my lord. Then, my lord, CRAN 4 has been filed, my
When
lord.
it was last rejected?
Last rejected on 29th July 2020.
29 July. How long you are in custody?
My lord, 5 years, more than 5 years, my lord.
Section?
My lord, 6 box, my lord.
6 pox.
So
My lord,
what is the change
inclusion in
in
the list, my lord?
what is the change in circumstances?
My lord,
Unnecessarily, why shall we release? No? If there is a change in circumstances, you can tell us.
my lord, advocate on
Otherwise, we will have to dismiss it again.
my lord,
what
kindly
purpose will
inclusion
we-
in the list, my lord. Inclusion in the list, my lord.
When did you file the application?
My lord, on
আমরা
My
দেবো
lord,
তাহলে শুনছি।
16th December,
Deed of detention custody.
around
এই
16th.
দুটো basis এ
26 জুলাই লাস্ট দেখতে রয়েছে
তারপরে 6 মাস হয়েছে 6 মাস হয়েছে তো এর মধ্যে যদি চান্স না থাকে মানে অ্যাপিলটা হিয়ারিং করা হয় তাহলে আমরা
সেকশন 6 এর বেলের কন্ডিশন আপনি বেল দেবেন
5 বছর কাস্টডি
So,
কাস্টডিটা একটা কোয়েরিটা থাকে জানেন
no, that mistake of fact.
Yes, my lord. Subhashish Mishra was on the
So
other.
I didn't, I recorded your something, I didn't see the file. You have checked up, na? It is mistake of fact.
Yes,
Final report, mistake of fact.
Mishra.
Yes,
Ah,
yes, item 1.
it's for admission of the first time appearance. Sections are under 302 and 201 of IPC. Conviction for 20 years.
It is within time.
Yes, sir.
You have also filed an application in connection with bail in connection with appeal.
No.
It's the advance.
Then CRAN 1 is there, CRAN 4. কোনটা গো? Yes, 64. মিঠুন সরকার একটা এটা কোনটা ফাইল ঢুকে গেছে তাহলে কোনটা এটা হচ্ছে তো মিঠুন সরকার প্ল্যানটা কি ঢুকেছে নাম তো আলাদা
CRA DV 64 of 25 এটা
তাহলে ওটা অন্য কোনো ম্যাটার।
অ্যাডমিশন তো শুধু
হ্যাঁ, ওর ভুল ফাইল ঢুকে গেছে। এই রেগুলার অর্ডার করে দিই, অ্যাডমিশন ইস্যু নোটিস সেন্ডিং হিপন প্রিফার
লিবার্টি
ওই কার্তিক report on limitation could not be furnished in
report
advance.
because certified copy not filed.
Legal aid matter, I have requested.
When was the judgment delivered?
It was delivered on the.
2nd September 25. And you filed it when? December 25.
Yes, sir.
3 months over.
2 months.
2 months is over. You have to come with a limitation application. Then you take appropriate steps in
The liberty to file.
Liberty be given.
Liberty to file section 5 application. For condonation of delay as it is beyond limitation. যদিও এখানে কিছু বলার নেই। কিন্তু from the judgment থেকে তো বোঝা যাচ্ছে beyond
হ্যাঁ, ও ফাইল করবে, আমাদের লিবার্টি দরকার আছে। When can you file?
Legal aid matter, I have to. Instructions of that.
No, if you can file the formal application, we will allow the delay and admit.
Exhibit portion, sir.
Pardon?
In exhibit portion, relatives of that.
Oh, I see. So do we, 23 তারিখ রাখি? Let us keep it on 23rd. If you can do it in the meantime, very good. 23 তারিখ রেখে দিও।
Number 2. I'm for the application. Appeal against.
Limitation is there.
by the victim.
There might not be limitation as because I have filed, there was a puja vacation and that's why the account might be.
When was the judgment delivered?
23rd of July.
July. আরো ফাইল করেছেন?
22nd of July, the judgment was delivered. I have applied for certificate copy.
2nd of July.
27.
22nd of July. Therefore, I applied for the certificate copy and I obtained the certificate copy on August 14th.
Report of. So but here আচ্ছা envelope মধ্যে আছে certified copy. দেখতে হবে কবে গিয়ে পড়েছে। দেখুন
এটা স্কুলে দাও ওনাকে।
এই এটাই certified copy.
And lordship, there was a puja vacation. I thought that if my account might be fine.
অ্যাপ্লাই হয়েছে 14/8/2025
তাই তো লিমিটেশন নেই। 27 জুলাইয়ের অর্ডার কবে অ্যাপ্লাই করেছেন?
14/8
14/8 তার মানে
on 14/8 you have applied for certified copy.
23rd of July, I have applied.
23rd July right 23rd July
জাজমেন্টটাই তো 27 জুলাই।
The very next date.
no judgment of
And I obtained the copy on 14th of August.
14th of August you obtained the certified copy
Yes.
and filed this case when
The case is filed on 10th of December.
10th of
December.
তাহলে তো হয়ে গেল
90 days, there is the limitation period.
না 60 ডেজ কেন বললো? 90 ডেজ।
14/8 তো হ্যাঁ অগাস্ট সেপ্টেম্বর অক্টোবর
কবে
নভেম্বর
জাজমেন্ট? কবে জাজমেন্ট?
এই যে 27/7
ডেট অফ সেন্টেন্স আর ডেট অফ জাজমেন্ট সেম।
জাজমেন্ট আগের দিন হয় সাধারণত এখানে দিয়ে দিয়ে
এইটাই তো জাজমেন্ট। দেখুন না ফার্স্ট পাতা তো শেষ। হুম,
22nd July,
হ্যাঁ 22nd জুলাই সেন্টেন্স হয়েছে 27
22nd July তো, ও
জুলাই
27th apply করেছে।
সেপ্টেম্বর
ও রাইট রাইট রাইট, এই 23rd অ্যাপ্লাই করেছে,
when did he get it?
23rd অ্যাপ্লাই করেছে, পেয়েছে 14/8।
23rd জুলাই থেকে 14/8 তাও তো লিমিটেশন হয়ে গেছে।
23rd থেকে তো 14/8 পেয়েছে, বাট 14/8 থেকেই ধরতে হবে।
সেই
তাহলে ও
23rd জুলাই তার সেখানে
পেয়েছে, পেয়েছে 14/8,
জাজমেন্টটা ডেলিভার্ড হয়েছে
27শে জুলাই, এই 23শে জুলাই,
27 থেকে 14 তারিখ অব্দি তো রান করবে।
23শে জুলাই, 27শে জুলাই সেন্টেন্স, 23শে জুলাই হলো জাজমেন্টটা।
হুম,
এবার ও অ্যাপ্লাই 23শে জুলাই করে দিয়েছে,
22শে জুলাই জাজমেন্ট।
23শে জুলাই,
আচ্ছা
এই যে 23/7,
তাহলে 14 থেকে কাউন্ট
তাহলে 14 থেকে হবে, তাহলে
তাও তো 3 মাস হলো।
3 মাস হয়েছে, তাহলে তাহলে সেপ্টেম্বর, অক্টোবর, নভেম্বর।
This is also legal aid.
No, Lorships.
So it is a limitation. Take appropriate steps. ওই 23rd জুলাই রেখে দাও। Why don't you check up and mention, sir?
Lordship, I checked.
Unnecessarily matters come and
It is delayed, unnecessarily delayed.
yes. You just hand over the slip without going through the records. Can you be able to file or we keep it in the next circuit? Tell us.
I will be able.
23rd
Let me
রেখে
set
দাও।
the things. Should.
না না না
Yes, next one.
Item of that for the applicant, my lord, there is a delay of 330 days.
See.
My lord, kindly fix on 22. My lord, today I will file the CRAN application.
So why didn't you say that? You should have said that. এইগুলো লিস্ট করার আগে সুরজিৎ দেখিয়ে নেবে তাহলে স্যার।
আর লিখতে হবে ডিফেক্টিভ বলে, তাহলে নিচে লিখে দিতে হবে ডিফেক্টিভ।
যেহেতু স্ট্যান্ডার্ড সার্টিফাইড করবে। স্ট্যাম্প রিপোর্টার তো ডিলে ক্যালকুলেটও করতে পারবে না। সে
সার্টিফাইড কপি নেই।
মানে যদি স্ট্যাম্প পেপার রিপোর্ট না করে আমাদের ফাইলটা না না, তাহলে পরে তো 23 তারিখ আবার কি হবে?
স্ট্যাম্প রিপোর্টার তো ডিলে কমপ্লিট করে দিতে পারবে না, বলবে ডিলে হয়েছে।
না দিলে পরে তো হবে না।
ও অ্যাডমিট করে নিচ্ছে ডিলে হয়েছে, অ্যাডমিট করে নিচ্ছে, সেই অনুযায়ী কন্ডোনেশন চাইছে। না, ধরে নিতে হবে ওইটাই, যবে থেকে জাজমেন্ট হয়েছে তবে থেকেই ধরতে হবে আর কি।
না তুমি ফাইলটা না দিয়ে স্ট্যাম্প রিপোর্টার তো তোমার সার্টিফাইড কপি ছাড়া দেবে না, দিতে পারবে না তো। কিন্তু আমাদের কাছে অ্যাপ্লিকেশন প্লেস করবে, অসুবিধা আছে।
ও অ্যাডমিট করে নিচ্ছে যে ডিলে আছে, তো ওইভাবে
23 তারিখে রেখে দেবে।
Good. I am for the same.
This is the bill in connection with the appeal. Before we enter into the niceties, Lordship, kindly see the cost list where two items are tagged
That you
together.
told us
The
yesterday.
second one is like I can say, appeal is the single bench appeal.
Yes.
So it has to be segregated because we only paper books have not been published yet. So it is kept along with only item number 4 will be here today. Because in
Yes,
5 they are on bill.
We will segregate it.
Lordship, that's it.
Where is the bail order in that single bench?
So we did not bring that file because they are in bail.
When did they obtain bail?
5 years imprisonment.
On the very first day there was.
All right, place the
And this petitioner was in custody for around 3 years. Subsequently,
3 years.
13th June 2025, the bail was granted by the single judge.
Just
13th June 2025. The rest of the accused were granted bail.
No, that is in that appeal, other.
Other appeal. This petitioner was in custody for more about 3 years, then subsequently his bail was granted by the court below.
When?
Lordship, they did not provide us, I apologize, Lordship, they did not provide us that information, Lordship.
To when he was granted bail?
That, Lordship, the judgment peculiarly
Date has not been given.
No, Lordship, that, let's see.
So what was the period he was in?
Around 3 years, my informations. And
After
subsequently.
that you got a bail. After
our-
custody of about 3 years you got.
bail. And subsequently, after the judgment, he was taken into custody, and since then he's. And
So judgment was delivered when?
judgment was delivered, Lordship, kindly say. 30th April 2025.
30th April.
April,
So from April 25 you are in custody.
in custody, subsequent, second stage. Now bill in connection with this petition. Lordship, this petition.
Previously no application for.
No, this is the first time. Lordship, this petitioner is the principal accused, being the husband of the deceased. The other accused persons who were segregated and
They
bail
have been
granted,
granted bail.
of the relatives, that means the father-in-law, brother-in-law, whatever.
Dying declaration is there. Dying declaration is there.
Declaration, two dying declarations. I'm coming to it. I'm coming to it. I am backed by judgments also. Though it is a bail application, but I do not take much time, precious time of my lords to go into the deep niceties. But overall, I'll satisfy that. First of all, Lordship, I take your Lordship to judgment, page 27, para 46. What prompted the trial judge?
Page 27.
Page 27 of the judgment, Lordship, para 46. What prompted the trial judge to pass the order of conviction? May I read, Lordship? Para 46. In the above factual background of the present case, this court feels tempted. The observation of Honorable Apex Court in the judgment reported AIR 2003 Supreme Court 691. I pause for a moment as because I'll be demonstrating that this judgment does not support the case of the prosecution at all. Wherein Honorable Court observed that deceased wife making statement that because of quarrel between her and accused husband, the husband poured kerosene and set on fire, similar to our case. Declaration recorded by doctor that the deceased was in fit state of mind to make statement, not challenged in cross-examination. Here the difference is, in our case, the declaration recorded by doctor does not have any certificate that the deceased was in fit state of mind to give the declaration, admitted by the doctor in cross-examination, and it has been challenged by us in cross-examination. So this is completely a different scenario. This statement can be said to be truthful and voluntary made in that case, as because there was a certificate that the deceased was in fit state of mind, and it was not challenged in cross-examination. In our case, there is no certificate, doctor admitted, and we have challenged the same. Now, in the instant case, the oral testimony, kindly note down, of PW7, that is the complainant, PW6, PW3 mother, PW10, PW11 medical officer, and PW13 remains. It should be unimpeachable. I don't know what this means, and consistently showing the capability of the accused and their participation in the crime. Now, Lordship, I will demonstrate that neither these statements, as found by the trial judge, helps the case of the prosecution. But before that,
But that is a question of trial. Mr.
yes, Lordship, but that's the point taken by the trial judge.
Sufficient matters on record to show that he poured kerosene oil. There is sufficient.
I will demonstrate that he was not there. It is admitted by the witnesses.
He said that I was not there. I went to Birpara, but I found that she has been transferred to another hospital, Jalpaiguri. The complainant.
Oh, his father. independent witness stated the accused were not in the house at the time of commission of the offence.
That was alibi, that is that they have taken disbelieved it.
That has been relayed, PW 13 court has relayed his statement. Lordship, then, church.
না না, ওই পোর্শনটা দেখছিলাম আর কি।
আচ্ছা, you place mine.
The
First of all,
that document was exhibited, dying declaration.
yes, Lordship.
Two
But
dying declaration.
dying declared. So one recorded by the police, 161 statement exhibited, another by the doctor. Now, before I enter into the niceties of the
No, read the next paragraph. Read the next paragraph.
Honorable Apex Court. Had recorded that dying declaration does not need a fixed format, however, it must be reliable, voluntary and
That is excluded. Next, in the instant.
in the instance there upon perusal of exhibit 2, it's seen the medical officer Dr. Devaprasad Das as PW 11 has corroborated that patient is clinically mentally sound to give declaration. Whether he has stated the same, I'll demonstrate from the evidence.
Okay, how many days before the death this declaration was taken?
Lordship. Then we should.
4-5 দিনের মধ্যে।
29th, 90th,
মারা যাওয়ার আগেই
died on 3rd.
ইনসিডেন্ট তো
See, died on 3rd, it was recorded on 29th.
29th and admitted when?
29th.
One died declaration by the doctor, 1st March, and by the police, 29th February.
Okay, that means 29th by the police and 29th by the doctor.
No, 1st March by the doctor.
1st March by the doctor and 29th by the
police.
police.
and she expired on 3rd.
She expired 3rd.
No, who admitted her to hospital?
The accused persons.
The accused
Accused
person.
person. Admittedly, before that, Lordship, I banked my case on a point which
Husband did not accompany.
husband.
It was taken by the in-laws. Husband.
Lordship, I'll show, Lordship, I'll demonstrate. Kindly bear me for a moment. Because
There are
husband.
strong incriminating materials. Mr.
Let's see,
Bambi.
Lordship, let's see. Lordship, if there are strong incriminating material without asking the questions in 313 to the accused person, can the court bank upon it? Matter of fact, this trial has ended.
The matter of ethics, hearing.
This is appeal. Supreme Court has categorically stated if the questions were not put
Come
to
to Supreme Court later, satisfy us prima facie.
page 40 of the compilation I have submitted.
No, regarding from where do we get that the
The
accused
330,
persons?
330.
No, accused persons and the in-laws took her to hospital from which?
From the evidences.
From the evidence.
Evidences. Lordship, can you see page 40 of my compilation? Certificate I have given.
Apart from burn injury, were there any other injury
No.
marks on the
No.
body?
No. And doctor opined it can be suicidal.
That is the post-mortem report.
No, he has postmortem and doctor opined.
Post-mortem report is burn injury.
Burn injury only, not homicidal again. Antemortem.
No, no.
Yes, Lordship.
Subsequently, it has said,
No, Lordship.
come.
Lordship, I'm coming, Lordship. I'm coming. Kindly see page
He
40.
first said it was suicidal. Next, he said that no, it can be homicidal. The person who postmortem doctor said that is recorded here. Come to page 29, paragraph 52.
Page 29.
Paragraph 52.
Oh,
First statement was burn injuries antemortem in nature.
Lordship,
Next,
Lordship.
para 53. It is during cross-examination witness fumbled and deposed that I could not ascertain as to whether the injury was homicidal, suicidal or otherwise.
I'm coming to it. If the judge has correctly taken the line, I'm coming to it. I'm challenging the judgment itself. Lordship, kindly see page 38. Dr. Probir Kumar Dev.
38 of the judgment.
No, compilation. I have given, Lordship.
38.
38. Chito.
Page 38 of
38.
your compilation.
Yes, Lordship. Dr. PW 19. Dr. Probir Kumar Dev.
Yes.
Kindly see,
So
Lordship.
Probir Kumar Dev, yes.
In my opinion, third paragraph.
No, let's read.
Ah.
On examination,
On examination, I found infected burn injuries present over neck, upper part of chest, both arms, forearms, lower abdomen, both thighs and both cup region and back.
Just a moment, I didn't get the page, sorry.
Page 38. Lordship. Singing of scalp hair present, all the injuries show vital reaction. No other injury except no notice about Lordship. What Lordship was asking. What fell from the mouth? No other injury except those noted above could be directed over the body. No foreign body directed.
Yes.
Brain was congested, such and such. Material, no untoward smell was present. Intensive liver spine. In my opinion, the cause of death was due to the effect of burn injury, antemortem in nature. Viscera has been preserved for chemical analysis for detection of any poison. That's another thing. Acha. PM has been exhibited, page 11. Now, as per burn injury, injury could be homicidal. Injury could be homicidal. Cross examination.
Where, that is in cross.
No, in chief.
in chief.
Where?
Last line of chief.
শেষের দিকে, as per.
Upon suggestion given by the state, as per burn injury, injury could be homicidal. Now, cross examination. I could not ascertain as to whether the injury was homicidal, suicidal, or otherwise. It might be suicidal. But this is also not my.
That is exactly what is recorded in para 23, 53.
Lordship.
Why you are saying it is different?
I'm coming, Lordship.
Para 53, that line.
He has taken only the cheap portion.
No. In during crosses fumbled and deposed.
After how many years this incident, from the date of marriage, this incident took place?
Date of marriage. FIR. Lordship, can you see the FIR? Lordship, 2009.
2009.
Within 3 years.
Within 3 years, the incident took place.
Prior thereto, there was a 498. There
498.
was a settlement between the parties. He
Lordship.
went back.
Lordship has seen.
সেটেলড হলো সালিসি করলে পাঠাবো, তারপরে গিয়ে বল
3 বছরের মাথাতে
3 বছর মধ্যে
মধ্যে আর
এভিডেন্স
অ্যাকচুয়ালি দুরকম হতে পারে।
at this stage of
সুইসাইডও হতে পারে, বার্ন ইনজুরি এমনি তো কোনো সন্দেহ নেই, সুইসাইডও হতে পারে টর্চারের জন্য।
সেইটাও ডিসকাস করেছে, সেটাখানে বলেছিল একটা উইটনেস কে দিয়ে দাঁড় করিয়ে বলিয়েছে she was an ill tempered woman, নিজেই ভেগেছে।
টর্চারও ছিল, ওর উপর যে টর্চার হতো আগে, এটা থেকেও কমিশন হতে পারে, সব রকমই সম্ভব আর কি। এবং ওর গাড়ি আর কোনো মারধরের চিহ্ন ছিল কিনা সেটাও
না থাকলেও একটা লোক আমাদের কাছে দেখছি there is enough sufficient material on record that he poured the kerosene. আপনি মনকে মানাতে পারলে যে
আমি তো অ্যাপিলের হিয়ারিং মানে সুইসাইডও হতে পারে টর্চারের জন্য, আবার ওর গাড়িতে তো যে কোনো একটা
Compilation I have given.
yes
The 313 has been recorded mechanically. Kindly see the answer of question number 3. Then question number 5. Next page, question number 6, question number 7, question number 8.
yes what you are showing.
রিগার্ডিং ডাইং ডিক্লারেশন, হোয়াট ইজ দ্য 313?
Lordship, kindly see first question number, answer to question number 3. Lordship is getting the answer.
Yes
What is?
answer is not there.
Yes,
It's
Lordship.
blank.
That is the thing, blank.
It appears that he attended. This is of Tazimuddin.
This is of Saidul Khan, that is the petitioner here.
এভিডেন্স অফ PW1 তাজিমউদ্দিন।
Every
From the evidence it appears.
the question answer is blank.
That was pertaining to the alibi, Mr. Ganguly. That
Lordship,
means
this is
that they were-
313.
Yes.
313.
Argue that in trial. We are in bail.
if
You show us prima facie apparent on record that this is the infirmity and this is the discrepancy, then we will consider.
Lordship,
Regarding dying
313
declaration, where
says-
is the 313?
kindly consider one thing, Lordship. Kindly appreciate one thing.
We will appreciate, but let us be
Because
satisfied.
I am asking bail as because his bail, he has been convicted and he will be taken into custody.
Yes,
If the 313 appears to be recorded mission.
show us dying declaration, what my
Yes,
brother
yes,
is
yes.
asking.
His dying declaration 313.
Dr. Devi Prasad recorded dying declaration in presence of two witnesses.
Yes, which question?
Lordship, 21.
21, yes.
Accused kept silent.
Silent. I did not answer anything.
Hmm.
But regarding the dying declaration of the police officer, no question was put to the accused in 313. No question whatsoever. Police dying declaration.
So that will nullify it.
That cannot be taken into consideration.
That is the law, my lord.
That is the law.
That is. The circumstances not
Had to
the
be
accused
explained.
cannot be relied upon during the, while convicting. him.
Regarding that police, it
Nothing,
cannot be
nothing.
put. But so far the doctor is concerned.
Doctor, it has been mentioned, I did not give any answer, which goes against me also. Now, regarding, if Lordship allows me, I will show that regarding the dying
It is
declaration.
on a composite consideration, Mr. Ganguly. You cannot segregate and highlight an issue. Had there been no 2D dying declaration, your argument we have accepted and granted the bail. Herein, admittedly, there were 2 dying declarations. You are showing us your argument is 313 pertaining to the second one is not there.
No, regarding the second one is here.
Now the question is,
There
had
was-
there been only one?
One.
Whether it is sufficient or not, whether this only one dying declaration.
Now,
So that is a question of trial. So
so-
that on this, you will succeed on this issue party if one dying declaration goes. There is another dying declaration.
now regarding that I am coming, Your Lordship. Whether that dying declaration can at all be taken into consideration or not.
Why not?
I am coming because it's against the guideline of Honorable Apex Court.
So that is an issue of trial, Mr. Ganguly.
But Lordship, at least this.
What is the apparent discrepancy?
Lordship, the apparent discrepancy when I was
Bail
in
is
bail.
my discretion.
Yes, Lordship. When
It
I
is
was
our
in,
discretion.
when I was on bail, when I was
That you have said-
I faced the trial. I did not
Bail in
abscond.
connection with appeal and other regular bail are very
Different.
much different.
Different because
You have
the-
upon full-fledged trial, you have been convicted. Allegation is 302, which
Yes,
you are
sir.
trying to disrupt.
Lordship.
Judgment was delivered. Judgment has been delivered on
30th April.
30th April. You have been convicted life imprisonment
Lordship.
on the ground that you have not misused your liberty, which was granted before the trial court. Can you claim a bail simply seated on that basis? You cannot.
Then Lordship, then for that, I have to enter into the evidences to show the discrepancies.
Yes, you have your argument. We have understood it. 313 pertaining to one declaration was not
Not there.
admitted.
Anyway,
There is existence of a second declaration.
second, now I am showing the second declaration at the primary juncture also cannot be taken into consideration.
Second declaration is of Dr. Devi
Doctor
Prasad.
Devi Prasad.
That is on 1st of
1st of March.
Other is of the police,
Police.
in which 313 was not.
Because I believe that police declaration was not believed by the court even, and that is the reason that no question was put regarding that. Because of a 50% bond patient giving vivid description, mentioning the previous case number, date, etc., is nothing but table word.
Yes, what is your next point?
Next, kindly comes to page 9.
Itself and bail is so and so.
Page 9.
Sometimes the first time we are not intending to marry.
Yeah,
Maybe it's like that
at this stage,
we're not entering into the marriage for the first time.
Yes, sir, you can.
We don't intend to enter into the marriage.
Wait,
at this stage বলবো তো
At this stage.
না,
at this stage আমি ওটা দেবো না
If it is not,
যদি না হতো তো তাই মনে হয়।
6 months এর মধ্যে যদি না হয়, you believe your prayer.
that is Supreme Court সেইটার ওপর পরের বারে ও স্টেটমেন্ট করতে পারবে
এটা তো first time হচ্ছে।
ফার্স্ট টাইম
Yes, page 9.
Page 9 is the recorded by the doctor.
Yes.
Now the question that fall from the mouth of my lord is that whether the
prompted
petition-
by the recordings not
whether
by
the
prompt.
petitioner being the husband took her to the hospital or not.
Now, is there any discrepancy between the statement made before the police and made before these doctors?
Yes, Lordship, there are very much discrepancies. In this, only the husband's name is there. In the police, everyone's name, every role, everything is there. Now, Lordship, here kindly says, কিছুক্ষণ পর, kindly may I read the
Yes.
গত সোমবার দুপুর 12টা নাগাদ আমার স্বামীর সঙ্গে আমার ঝগড়া হয়। আমার স্বামী আমার শাড়িতে কেরোসিন তেল ঢেলে গ্যাস লাইটার দিয়ে আগুন ধরিয়ে দেয়। কিছুক্ষণ পর জল দিয়ে আমার স্বামী আগুন নেভায় এবং বীরপাড়া হাসপাতালে ভর্তি করায়। So is the husband who took her to the বীরপাড়া hospital?
page 9
Page 9, Lordship.
sir don't interrupt let him he's already in tension because he's arguing we are pestering him what can be done he has to withstand that
So is the petitioner who took her to who poured water and took her to the hospital?
No, that means you see, he is also not blaming the accused person, he is accepting that the accused person has
But-
both allegation as well as his work.
Save the life. As because if we take this declaration to be gospel truth, my humble submission is that what she has stated is that out of
Any seizure was there, kerosene bottle or something like that from the place of occurrence?
that is arguing
Kerosene bottle and the gas lighter and all this.
probably not. Have to see what is there that due to that fight, sudden fight, the incident happened. But after realizing it, is the husband who poured the water.
we
who-
could have appreciated that Mr. Ganguly but it has a previous trail there
498A.
this dispute is not a provocation incident occurred
Lordship,
we could have granted you on that ground
Lordship, what she stated,
she is admitting
সোমবার দুপুর 12টা নাগাদ আমার স্বামীর সঙ্গে আমার ঝগড়া হয়।
very good
আমার স্বামী আমার শাড়িতে কেরোসিন তেল দিলে
So
গ্যাস
does the, on this statement, does it mean that the previous incidents goes?
She did not narrate anything.
How can she narrate at that stage? A woman has been put to fire. She is being taken to the
I
hospital.
am grateful Lordship has put this question, but kindly sees the 161 recorded by the police officer. Even the case numbers of previous 3 years has been mentioned.
Naturally.
So how could she say? How could she say? Same logic? Page 7, Lordship. It's a table word.
Page 7.
Page 7, Lordship.
Why, sir, there will be, why you are going to that extent? It is not a case of personal grudge of the police against you. It is a question you have to accept it on the sequence of facts which had occurred. You are
Kindly-
arguing that it's a table you are taken-
Kindly consider both the dying declaration and what Lordship has just.
What you are showing, page 7?
Page 7 is the statement recorded by police.
Yes.
The first part, the entire first part regarding the date of the previous case.
Anyway, this was disbelieved by the trial
Disbelieved
court.
by as because no question was put.
Yes.
Now, this is the statement. So what?
So
my
this is 28-2 probably,
Hmm.
28-2. And the doctor's declaration is
First March,
on the following day.
following day. Can you see page 9, bottom?
Yes, the incident is on 28-2 probably.
Police is on 28. 29-2.
No, 28-2 is the recording police statement.
Kindly see page
Okay,
8.
29-2.
29-2.
29-2.
This is 1st March
Okay, 29-2 is the incident. And the following day, doctor's statement.
Doctor statement. Now kindly see what the doctor has stated. What number? PW 11. What number? Page 25, Lordship. The doctor who recorded this statement. What is Lordship?
Yes.
Okay. Page 25. North Bengal Medical College, he gives the in examination chief. Now cross examination, Lordship. Next page. 1, 2, 3, 4, 5, 6th line from top. I have not tested the patient for her mental alertness. Besides the declaration, I have not issued any certificate regarding physical and mental fitness. Then, just a few. There is no note in dying declaration who informed me for recording this dying declaration. I can't say percentage of burn of the said patient. I cannot say in which limb she sustained burn injury. I cannot also say whether hands of patient was burned, but these are answered by the postmortem doctor. After recording statement and observing all formalities, handed over the same to medical superintendent come vice principal, North Bengal Medical College and Hospital. There is no note in dying declaration. Fact remains, police authorities did not seize this document from me. There is no note regarding voluntariness of patient. Now, from where this dying declaration came to the case record is unknown because there is no seizure list to that effect even.
But he has admitted to have taken this dying declaration.
Dying declaration.
That is
But
there.
it was not seized by the police, and there is no note to that effect even, and there is no seizure list prepared by the police from whom this dying declaration has been obtained even. Now,
So your argument is there was no dying declaration.
no, there. If we, I'm not saying anything.
That is what
I'm
you're saying. That is that don't go into that also. It is not a dying declaration, not seized, get lost. You're saying that.
Lordship, I leave it up to the wisdom of my lord. I leave it up to, we are before the highest temple of justice of the state. I leave it up to the wisdom of my lord. Now,
We appreciate your argument, but the thing is,
Lordship,
you are trying to tell us that don't look at the dying declaration. Don't put your eyes there.
Lordship, what I intend to submit is that there are questions regarding
Try after a few months. Try after a few months, not at this stage.
Then Lordship, keep this without rejecting it, then change of circumstances will be.
Next time. After arguing, we will defer
See,
the.
then please allow me to conclude my argument.
Yes, we are not stopping him.
Then few lines below. There was in impression why I am submitting, Lordship, that this dying declaration is not of the deceased.
Only thing is this, PW2 said that in the kitchen, the body burned, the caught fire.
Caught fire.
Only this is PW2. PW2 was declared hostile. PW12.
12. Lordship company comes to the bottom portion of page 26.
Page 27.
26, where I was reading, Lordship, the doctors.
Yes.
What is, Lordship?
Yes.
There was in impression in LTI.
Page 20.
There was in
26.
impression in LTI. Page 26, Lordship. The doctors, dying declaration doctors.
Skin impression.
Skin impression, that is skin impression. But postmortem doctor says the entire palm was burned. How the skin impression came, Lordship? I ask a question to myself.
So this cannot be gone into at this stage, okay? Prima facie, except you see PW12, whether PW 12 is sufficient.
Below 13.
This is, sorry, this is deposition of witness number 12. That is Moizuddin Mia, where he said the wife of Shahidul caught fire in her matrimonial home.
Lordship.
This is only,
Lordship. And not declared hostile even.
yes,
No,
sir.
we have heard.
Yes. I've heard wife done, I can't say how she got fired. Yes.
We heard.
Lordship, can you see?
No, sir.
Can you see
Got
PW
fired.
13 then? PW 13. This witness was also not declared as hostile and banked, relied by the court.
PW 13. Yes.
Independent witness. May I read, Lordship?
Yes.
I know Shahidul Khan, he is my neighbor. His marriage was held with Babli Begum. Babli Begum is now dead. Babli was tried out with burning condition on her person. Myself and Anjuma tried to save Babli. At that time, none was present in her matrimonial house. Incident took place about 1 year 9 months ago. Back from this date, this witness saved Babli as per this witness, not declared
So what is
hostile.
the cross-examination done?
Cross-examination. Shahidul was present in a neighboring house where a marriage ceremony was performed and Samsul
এই ক্রসে আলিবাইটা আলিবাইটা চাইতে পারে তো এখানে কেউ ছিল না, ও বাঁচাতে গিয়েছিল। এটা অ্যাকচুয়ালি ইট ইজ রং বাই সবাই এখানে বলছে শাহিদ ওয়াজ প্রেজেন্ট ইন এ নেইবারিং হাউস ওয়্যার ম্যারিজ সেরিমনি ওয়াজ টেকেন। এটা ও ক্রসে এসেছে।
With Samsul along.
ও আলিবাইটা ওটা অ্যাকসেপ্ট করেনি।
এবার তো hostile declare.
he was not declared hostile. So it was relied upon by the prosecution.
ইস্যুস আর ট্রায়াল কোশ্চেন হলো এইটা যদি আপনি হোস্টাইল করেনি বলে আপনি এন্টায়ার ইনসিডেন্ট আমরা ডিসবিলিভ করলাম টাইম ডিক্লারেশনের টাইম আর এই ইনসিডেন্ট ও বাঁচাতে গিয়েছিল এইটা পরে বড় দুটোকে দেখে
Not declare hostile to this witness, which means she has stated before the court
that there was no one in the
no, whatever she has stated during her statement under 161, and that is the reason that she was not declared hostile. So it is this person and Anjuma.
No, question is in the admission report, what did the doctor say regarding who admitted her to hospital? That is also a ground.
Lordship, the doctor who
So whether this person evidence can be relied.
Lordship, we don't have those documents with us. The state.
How can I?
Those were exhibited
No, those were not exhibited even.
because in the admission register, because somebody was admitted in a bond condition. There must be,
Lordship, kindly sees what are the documents which were exhibited in judgment, Lordship, in page 3 of the judgment. Medical report. Yes, na. Lordship, the TCRs are here. Lordship can see exhibit 3 medical reports.
Admission rate generally 6 quarters. Generally 6 quarters.
Lordship, can you see grand declaration, medical report, inquest report,
page 3,
page 3 of judgment,
page 3,
of the judgment,
inner page 3.
inner page 3. Certified copy I have given, Lordship.
Inner page 3. Bottom report.
Lordship is reading the judgment.
Page 3 of the free copy. Yes.
Yes, Lordship. And
Then-
the written complaint, signature of endorsement of SI Tamang, dying declaration, medical report, inquest report, formal FI, rough sketch map in the carbon copy of Caesar list, statement of disease, inquest report 174, postmortem report. That are the only
Exhibit 3 is the medical report.
medical report. It's the injury report perhaps.
Injury report and in the while admitting to hospital,
Lordship, the TCRs are here. Calcutta registers are here. Records.
who admitted this person, whether the accused or
The
the,
accused admitted. Lordship, the
no, as per the victim,
No.
accused admitted. But so far this person is concerned,
but
it is the,
who gave signature, then that I don't know.
no, if this person's statement, evidence is to be believed, they admitted the victim to hospital.
No, it's admitted that from the deposition of the mother and other relatives, they stated that the accused person admitted.
Because they don't know the local persons, that is why they said.
Lordship, can you see page 29? Dr. Abhijit De, attending medical officer of Birpara.
Yes.
Cross-examination. The said patient came to our hospital along with her husband.
Where page 29.
Page 29. 1, 2, 3, third line cross-examination. The said patient came to our hospital along with her husband.
Who is this Abhijit there?
The doctor who attended first
So 50% burn condition.
was taken by the husband, admittedly, Lordship.
Come to page 17.
17.
What is the deposition of Muslim Haq? Come to page 18.
Lordship, he is a family member, Muslim Haq. Interested event.
Page
No.
70.
17 Muslim Haq হয়েছে গেছি তো শুধু ইনলস
So Muslim Haq's deposition, if my lord allows me, I'll show that it is totally afterthought. Totally. Because Muslim Haq's statements are contradicted by the investigating officer himself.
Yes, anything else, Mr. Ganguly?
Lordship, Muslim Haq, as my lord has taken Muslim Haq, can you see space 17?
That is different to these doctors. These admission.
Not only that, negated by the investigating officer himself.
What is your argument? That the
My argument
husband,
is-
after the incident, husband took her along with to the hospital.
To hospital, try to save her.
Hmm.
So 302 does not come. Maybe out of anger or anything,
No,
the
but this
incident
is the
occurred.
question to be decided.
These are
in
facts.
trial,
But at
Mr.
present,
Ganguly.
Lordship, kindly consider.
There is sufficient material on record to suggest that there was a burn injury, there was a dying declaration.
The-
You are saying validity of dying declaration is in
That-
question. All right, we accept. There was a dying declaration. There are inconsistencies in the evidence which has been tendered by different persons. And on this ground, 302 conviction was not possible. So you give me.
Lordship,
This is your argument.
No, Lordship, at best, at this juncture, kindly consider from the dying declaration, if you take the declaration of the doctor, of the victim before the doctor, as well as
How can we shut our eyes to a fact that is a bail in connection with appeal?
Lordship, I'm coming.
On the basis of evidence decided. So the infirmity in the evidence which you are arguing today is a good ground of argument at the time of trial.
Lordship, at present, at
No,
the
you see,
present-
it's 27 to 2012, you see, that is the PW 14.
Lordship,
So according to the medical officer, the patient was conscious. So whatever she stated, the doctor recorded, the husband was there, okay? So 27 to And he has referred the patient immediately for medical examination.
And he did not record the statement of the patient.
No, question
It
is,
is recorded subsequently.
and I noted the same in my medical examination report.
Report.
So exhibit 3 is the medical examination report.
Kindly goes through the medical examination report.
What he stated, because
Lordship.
you
Lordship,
see,
what
her
did she state?
because you see, her husband was beside her.
Lordship.
Okay, she may not be in a position to say everything, but
Lordship.
when the dying declaration was taken, husband was not
Not
beside
there.
her.
Not there.
So that is the thing.
Maybe.
So in the
But at this juncture, kindly appreciate one fact. That is it is the family member and the petitioner who took her to the hospital. Who took her to the hospital?
All right.
The co-accuser and on bail.
no co-accused, there is no allegation of pouring
Here,
kerosene oil. Okay.
Lordship, there are allegations. There are allegations, Lordship. Kerosene oil putting, there are allegations against co-accused also.
But anyway, it is not founded. But
It is not.
so for the
because
dying delay, dying
allegation is omnibus.
Yes,
Dying
what
delay-
do you have to say? Yes, what do you have to say?
Well, I'll be very brief.
Mr. Ganguly has been brief.
Mr. Ganguly has elaborated a lot. I'll be very brief.
সারাদিন বসে থাকলে শোনা
One of the primary things.
একটু happy শুনতে হবে তাহলে।
Yes, ammonize. Always ammonize. Or I'll be very brief.
Sure, I'll be banking upon the judgment.
All right, let
আমাকে একটা
me, in
copy দিয়ে
reply,
পড়তে চাইছি।
in reply, you tell us.
My lord, the first thing is that what is the principle behind this appreciation of a bail application, evaluation of a bail application, post conviction stage. Now, a person, there is always a presumption of innocence during that trial. Once a man is convicted by a competent court of law on appreciation of evidence, full length appreciation of evidence, my lord, the presumption of innocence subsequently goes on. At this stage, the presumption of innocence is not there. This is Supreme Court judgment. Pitpal Singh is the judgment of the Supreme Court explaining this point, my lord. If my lord requires, I can print it out and I can submit. This is the principle. Now, another principle, my lord. Whatever Mr. Ganguly submitted, that, the fitness, the certificate, all technical issues, man. The primary principle behind acceptance of a dying declaration is no one will meet his maker with a lie in his lips. That principle has a topic.
What?
No one will meet his maker with a lie in his lips. It was the last statement made by her.
That has been overruled now.
No. Mr. Ganguly, did I interrupt? You are senior to me. I know that you know a lot of law. But don't interrupt. My lord. Thirdly, my lord, Mr. Ganguly heavily relied upon certificate, mental fitness, these points. During the entire trial, they have never denied the fact that she was unconscious, she was conscious. Rather, during the cross-examination, my lord, and kindly come to PW, page 13 of their compilation, my lord. 11, 12 and 13, specifically page 13. In the cross-examination, they have taken this point. Babli disclosed that her husband lit fire on her person after pouring kerosene oil. This is the part of the cross-examination.
12,
Page
Page
13.
13, my lord. It's part of the cross-examination.
that is a cross-examination of
Cross-examination of Manwara Begum. Correct.
Rahinu's bibi. 28, you said, na?
13.
13. Page number 13.
1-3 of the compilation.
Manwara Begum.
Manwada was the mother.
In her cross-examination, they have admitted that she was conscious. He cannot blow hot and cold, my lord. See,
Where do you showing? Page
paragraph
30.
page number 13, man. 1, 2, 3, 5, 6. Sixth line, man.
Yes. My husband was also present with me at Pitpara Hospital.
When my daughter disclosed everything.
Which has been denied by the husband, Lordship.
No, it is not the case. I am aware of, I am concerned about the consciousness. You have admitted in your cross-examination by putting this question that she was.
No, it is a case of the defense also that the husband admitted her.
Admitted her. My lord, the consciousness, her consciousness. Now they are claiming that whether she was conscious at the time of speaking, making the.
No, he has not said.
No, the certificate, what is the necessity of a certificate?
He
Mental
has said,
fitness.
that he has not harped on the issue major in total. He says that the dying declaration which was obtained, I can show you prima facie there are discrepancies in that. We
That-
should limit ourselves to that issue. We
Well,
are not going into
Since
the.
there is a dying declaration and he has been convicted
So
of
the
that
discrepancy which he is pointing out cannot be ruled out at this
at
stage.
this stage, my lord.
Yes.
The appeal hearing is necessary for that, with the help of the paper book and
Yes.
all exhibit.
Anything else you are?
exhibit files.
Anything else you are wanting to show?
But this is my brief argument, my lord.
That there was a clear statement
Clear
that
statement
he was
in-
conscious.
The medical evidence corroborating it,
Hmm.
the cause of death and the circumstances of transaction resulting into her death has been explained by her.
No,
Other
this,
witnesses
where
support-
is this admission? This is the statement of the victim's mother.
Yes, my lord. During the
In
cross
examination, she said, my husband is present at Birpara when Babli. My husband was present at Birpara. This has again been contradicted in the judgment. Because from Birpara he was taken to Jalpaiguri.
Thereafter to NBMC.
Now was present at Birpara when Babli disclosed that her husband lit fire on her, pouring kerosene oil. This is the disclosure made by the patient. There
It
is a
is taken
person.
during the cross examination. During the once you
Cross, yes.
Yes, my lord. He cannot escape from that. Babli made something,
Examination also
stated
Babli
something during
told
the
me
cross
that
examination. If
her
it
husband-
comes, there is no escape from it. There is no escape from it at this stage, my lord. At this stage, I am opposing the bill, strongly opposing. The innocent lady died. She was subjected to inhuman torture in the matrimonial home.
Her husband put kerosene oil.
Prosecution
My daughter told me that her husband put kerosene oil on her husband. That was the point. Process মুখ দিয়ে তো ঠিক কথাই বলবে। Process বলতো এই একটা জায়গা তোমরা করেছে। আর husband যে ছিল
Again in page 18, my lord, they have admitted in.
husband ছিল।
তুমি করো নি তো বল।
হাজবেন্ডের সঙ্গে এক কথা নাও বলতে পারো। হাজবেন্ডের
ঠিক আছে হ্যাঁ ইয়েস দারুণ করেছে দেখুন
ইয়ে করেছিলেন টিচার let it appeal be expedited. Appeal expedited. Even appeal is not heard, but
Yes. Yes.
Lordship. First, I would like to give answer to what he has pointed out. Subsequently, I am coming to my submission for today, ending up. Lordship, here, what he is being banking upon is that disclosure of Babli before her mother at Birpara Hospital. He is saying that patient was concerned because Babli has made this statement in presence of his mother and father. What has been stated by the mother? I submit this is a totally afterthought and a false statement as because the father told he never went to Birpara Hospital. The father told he never went to Birpara Hospital. So,
Yes.
what the mother has stated that I went to Birpara Hospital, Babli with my husband. When the Babli told me this and that, the father was also present. Was totally denied
no,
by
you
the
see
father.
two things. You see, this victim has told what it appears, told her mother about her husband pouring kerosene oil, and the other is to the doctor who has these two things are on the record. So it cannot be disbelieved that the victim said to her mother, forget about the police officer, to her mother and to the doctor who has recorded the declaration.
But kindly appreciate one thing. What my lord has just a few minutes ago, my lord has what suggested me that perhaps the husband was present in Birpara Hospital, so she could not declare anything.
No,
to the doctor,
that is on
to
the
doctor.
29th.
That is my brother was.
Yes,
there.
29th.
But in Birpara Hospital also, her husband was there.
No, when the mother was talking with the child,
So
there was no scope for the husband to be there.
the husband took her to Birpara Hospital.
No. You see, in a doctor's chamber, the husband and the victim was there in the doctor's chamber. But at the time of the declaration, that husband.
Declaration was not at Birpara Hospital. Declaration was
Yes,
Shifley,
different
subsequently.
hospital. At that time, the husband was not there.
Not there.
So she was in a free state of mind.
So if the victim did not say anything to the doctor of Birpara Hospital as because the husband was present, what my lord opined. So here also the husband was present in Birpara Hospital. But we find that Anyways,
These are the two things.
Two things.
One is in presence of her
During the
husband, the
night,
other
in
is.
the evening, she was admitted to Virpada Hospital. During the night, she was referred to Jalpaiguri, then NBNCH, my lord. This is how it happened. This victim had to travel from one hospital to another.
Bidpara, Jalpaiguri and then
And
Siliguri.
CH, my
Did
lord.
the prosecution show any document that she was taken to Jalpaiguri?
The evidence.
Or she was, Lordship, last submission. Lordship, kindly appreciate what my lord has stated, that I have a good case of argument. Now, if we say that we are ready, if my lord hears, to do the argument, we cannot, as because the paper books are not ready. I bank upon now Kashmir.
No, I said that the argument advanced by you is a proper argument at the stage of hearing of appeal.
Now, Lordship,
You are seeking bail because of this reason that there is no scope for disposal of the appeal.
now, Lordship,
So you grant me.
now, Lordship, we are ready to do the final hearing. Now, the paper books are not prepared, so I take refuge of Kashmir Ashing, Lordship. Court cannot say that I cannot hear your appeal, but keep you in custody. Kashmir Ashing.
Circumstances are there.
So that liberty will be granted if the appeal is not heard out, definitely.
Ashok, the appellant in CRA DB 29 of 2025 has filed the present application being trans. Wait. 1 of 2025 for suspension of sentence imposed by the learned court below. Stop. The appellant has been convicted of an offence under section 302 of the Indian Penal Code and sentenced to life imprisonment and to pay a fine of rupees 20,000 and in default to undergo further imprisonment of 1 year. Next paragraph. Mr. Ganguly, learned advocate appearing for the appellant, submits that the appellant had already suffered incarceration for about 3 years.
Lordship, after that, April, May, June, July, August, September. 3 years, 8 months, more than 8 months.
More than 3 years, 8 months. And there is no possibility towards early disposal of the present appeal. Stop. There are contradictions in the testimonies of the prosecution witnesses and is a prosecution.
There are contradictions in the testimony of the prosecution witnesses.
Prosecution witnesses and in view of several infirmities, no reliance ought to have been placed on the dying declaration also. Stop. In the said conspectus, in view thereof, there is every chance of success in the present appeal and the present appeal, which is already for a period of 3 years, 8 months, or no, 3 years, and he has not misused such liberty. ওইটা ওখানে ঢুকিয়ে দিয়েছে। আচ্ছা। Mr. বিশ্বাস, learned advocate, appearing for the state, opposes the appellant's prayer and submits that the sequence of events establishes the complicity of the appellant. Stop. There is no patent infirmity in the order of conviction. Stop. The appellant has already been found guilty by the learned court below on the basis of the evidence on record and while considering an application for bail in connection with the appeal, and while considering an application for suspension of sentence, it is not open to reassess or reanalyze the matter, reanalyze the same evidence and take a different view. He further says that in view of the severity of the offense and the strength of the prosecution case, the present application is liable to be dismissed. Heard the learned advocates and considered the materials on record. Stop. There is a difference between grant of bail under section 439 of the code in case of pre-trial arrest and suspension of sentence and grant of bail, post conviction. No, there is a difference. In case of pre-trial arrest and grant of bail post conviction. Stop. The mere fact that the appellant was granted bail during trial and he did not misuse such liberty cannot per se, cannot per se be a ground for bail in connection with the appeal. Stop. We have considered the quality of the evidence. We have assessed the quality of the evidence recorded by the learned court below. Stop. We do not find any strong and compelling reason to enlarge the appellant on bail at this stage. Regard being had to the prima facie merits of the appeal, evidence on record and observation of the learned prima facie on the merits of the appeal. Stop. Having regard to the severity of the offense and having regard to the severity of the offense and the reasons discussed above, we are of the opinion that it is not a fit case for suspension of presence. It is not a fit case for grant of bail to the appellant at this stage. It's dismissed.
Show liberty.
At this stage, we said.
Thing is, what when I'll file once again,
At this stage, we have said, Mr. Gandhi.
obliged.
Number 6. This case has got nothing entertaining, very boring. It can be spilled over to the next circuit. I will explain what has happened. Previously, it was decided. It was decided, item 6. It was decided in my favor. The regular second appeal was dismissed. We informed the client accordingly. Order was uploaded. Order was shared with the client. The client had a very happy moment. He made a little bit of a dance move and all. And then, milords, it was recalled back because there were certain defects in the file. So today, whatever will happen is a sequel or a remake of something that has already happened, milord. It is for them to remove the defect. It can be taken over in the. So all the fun and entertainment has been taken by the predecessor bank. It has become very boring now. Nothing is there.
It was admitted first.
No, at the time of admission, milords, we preferred certain Supreme Court judgments saying that merely because somebody has a record of right does not give any title to them. And the only document that they had forward was a record of right, that too an LR record of right, not an RS1. Based on that, an order was also passed, dismissing the second appeal.
That was on 24th of.
My lordship. Then after the order was passed and uploaded, it was realized that the defects have not been removed. So that is how it was again recalled for.
Lordship, the defect
And that is not something that he can remove because that defect
has to be removed from the learned trial court.
First appellate
Learned
court.
trial court.
First appellate court.
On the joint prayer of the parties, comma, the matter stands adjourned.
So enable the learned counsel for the appellant to remove the defect, not let it be adjourned till the next session.
You have to remove.
Lordship,
Yes,
the
yes,
learned
yes.
trial court,
You are
advocate
the
is-
appellant.
Yes, Lordship.
So you, why your appellant should be here now, Mr. Mishra?
No, you do it this way. The respondent is this side.
Oh, so. You are for the appellant?
Yes, Lordship.
Yes, what defect was?
Lordship, the defect is of such nature that it can only
I will
be
explain this.
corrected
In the
from
cause title of the trial court and the first appellate court, the name of the plaintiff
Yes,
is
sir.
different.
Yes.
So the correction of degree has to be done.
তুমি পিছনে রিকল করে দিলে জজমেন্টটাকে সামনে মেরিটে যেটা ফিলো ছিল আর কি
সেটা তো কারেকশন তো পুরিও জজমেন্টেই
বলা থেকে দেওয়া যেতে আছে এখন আবার নতুন করে
কেন নতুন করে শুনুন। What is the defect, Mr.?
In the trial court, the name of the plaintiffs are different. Now, some of the plaintiffs they died.
Yes,
Sorry, some of the respondents they died. Those respondents had to be substituted at the time of the appeal.
he was
That
not
sub-
substituted.
That
They were-
substitution was not done properly by them. No, no. In the trial court also they lost. In the first appellate court also they lost. This is the regular second appeal.
Very good. Now the substitution was not
They
undertaken.
never did it.
So it becomes abated then the matter goes. How can you correct by filing a substitution now?
No, not here. Before the first appellate court.
Right, first appellate court, it was, the order was passed on against deceased persons then, because substitution was
Some
not.
of them were substituted, some were not substituted.
So,
Yes.
so far as those defendants are concerned, it is abated.
Abated, deemed to be abated.
So what step will you take?
otherwise করতে হবে remit back set aside the appellate court's order take the granted them liberty to take steps and then proceed
ওই তো রেখে দিয়েছে এখানে। বিলকুল করে আবার এখানে
ওটা যদি অ্যাবেটেড হয়ে কি থাকে তাহলে এন্টার থিং গোস
চলে যাবে তো।
so grant them liberty to take necessary steps in accordance with law
ওর লিমিটেশনটা কন্ডম হয়ে যাবে।
সেই যা করবে করবে ট্রায়াল কোর্ট অ্যাপিল কোর্ট উইল টেক স্টেপস ইন অ্যাকর্ডেন্স উইথ ল তখন একটা টেকনিক্যালি দিকে চলে যাওয়াটাও তো ঠিক না
সেটা করে ট্রায়াল করতে আর নতুন জাজমেন্ট দেবে না।
না চলে গেলে পরে লিবার্টি তো তার তো রাইট থাকে কারণ যদি সাবস্টিটিউট করে তাহলে নতুন করে তো কজ অফ অ্যাকশন এসে যাচ্ছে কারণ ওটা তো সব চলে গেল ওটা তো আর অ্যাক্ট করা যাবে না ওটার উপর
আমরা তো এখানে রেখে দিচ্ছি না, বলছি লিস্ট করো এসে
তাহলে এইখানে এটা রিকল্ড হয়ে গেল এইটা ঠিক আছে এটা রিকল্ড হয়ে গেল এবার ট্রায়াল কোর্টে যদি ইরেগুলারিটি থাকে
সে একটা ডিসপোজ
না আপনি যদি ডিসপোজ করে দিও আমরা ট্রায়াল কোর্টে পাঠিয়ে দেবো মানে অ্যাপিল কোর্টে পাঠিয়ে দেবো
কোথায় করে দিই।
হ্যাঁ তাহলে জিনিসটাকে this appeal has to be disposed by granting the liberty to take steps to the appeal court as because it was already abated সেটাই আমরা তো রাখবো
For the correction.
কোঅর্ডিনেট বেঞ্চ বলেছে স্যার শুনবো।
না 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 শুনে তো লাভ কিছু হবে না ওইখানেই দাঁড়াবো ধরুন শুনলাম শুনে তো ওই লাভ তো
So we will dispose of the second appeal, giving him liberty to make necessary, take steps there.
Once the second appeal is disposed, will you be able to come back?
no no question is the lower court the trial courts will proceed in accordance with law after granting them opportunity to make necessary
There
application
is no error with the trial court. The error is with the first
very
appellate
well
court.
the first appellate court will take steps in accordance with
In
law
accordance with law after the correction of the.
yes after and then
correction
reheard
of
the parties
That can be done.
So for that, the order of the first appellate court has to be set aside.
yes yes not on the grounds of merit
I
but
don't know সেটা আমরা। So what is your?
Maybe what can be done?
I don't know what had been the complications inside, we do not.
Maybe what can be done is. let it
Today,
be-
if we set aside that first appellate court order, we are entertaining an appeal which has defects.
Which has defects. That is one
We have to
predicament.
pass order in the second appeal,
Yes, that is one.
in respect
predicament.
of which a coordinate bench has said that
That
you
is
go
why
and.
the coordinate bench was of the opinion that it be kept pending and they remove the defect and come back.
কি করে এই সেকেন্ড অ্যাপিলে ওই অর্ডার পাস করে সেটা সাইড করতে পারবো?
ওদেরকে লিবার্টি অলরেডি দিয়ে নাই যে Recall the judgment. আমরা
সেটা
judgment-
করুক দিয়ে, তাহলে এখানে আসুক করে।
The coordinate because the was of the opinion that because the appeal itself has become defective, they need to correct it and then come back.
No, no, my brother is not saying that. My
What?
brother is saying there was substitution not done, issue of abatement arose, which can be appropriately dealt with by that court itself.
That court itself.
Yes, upon granting liberty to the party.
So my brother is saying that we can dispose of the appeal, setting aside that order with liberty to them to substitute. But there is one predicament, because we will be passing an order in a defective appeal.
Yes, yes, that is what even the coordinate bench said. And therefore it was kept pending so that they cure the defect and
Yes.
come back.
Like that. So this second appeal, it is a one take. And then with our high court said that they want back to the court, touching it. They will give, you're the
No, no, but in this case, the order was already.
No,
passed.
Mr. Roy, that is in fact pendency of the matter for substantial. Ultimately, fate is known to everybody.
Yes. It
Because
was
after
first item that
removal,
has to be corrected.
in fact, strictly speaking, the defect cannot be removed because the court has to hear on the issue of substitution.
So
Only-
it has to be done by the appeal court, a first appellate
Yes,
court,
yes.
that substitution matter.
Yes.
So no use keeping this matter pending here. With that observation, we could have relegated it to the first appellate court, setting aside that order and consider his substitution. If not allowed, that order will revive.
You come back again on merit.
That after that, whether there is no use keeping this, but
Department when you get to some.
I have lesser experience than
No.
this.
Because no fruitful purpose will be served by keeping this pending.
Cooperative expert. The learned advocate appearing for the appellant prays for an adjournment to take appropriate steps.
Before the first appellate court.
না উল্লেখ করে দেওয়াই ভালো।
না না বলে দেওয়াই ভালো কিসে, কারণ নইলে পরে অ্যাম্বিগুইটি থেকে যাবে।
আচ্ছা ছেড়ে দাও, ওটা সাহেবকে দিতে দাও।
This learned advocates for the parties are present. This matter is put up for consideration in terms of order dated 28/11/2025 passed by learned coordinate bench of these courts. By order dated 28/11/2025, learned advocates were, or the appellants was granted leave to cure the defects. Stop. It is submitted by the learned advocates for the parties that before the appellate court, which party died?
Before the trial court and the appellate court.
Before the trial court and the appellate court?
Respondent needs to be corrected.
No, appellate court, on
One of the defendants. So
one
the
of-
arrow of defendant needs to be.
one of the defendant respondent died
Yes.
during the pendency of the appeal.
After the trial happened, before the appeal.
Okay.
বলবেন না, ওর
Okay,
confusion.
whatever it is, because some.
For correction of the cost item.
Yeah, for correction of the cause title before the learned appellate court.
Yes.
So
Yeah.
thus,
Yes, Mr. Mishra, you have seen the records and saying
Yes,
we
yes,
are,
yes, no.
on believing your statement, we are passing.
yes,
I will explain
Lordship
what.
might be learned trial court or learned appellate court.
okay,
I'm not
both
sure.
before the learned trial court and the appellate
Yes,
court.
Lordship, it will-
In the facts and circumstances, no fruitful purpose will be served by keeping this appeal pending. Thus,
No, no, appeal to pending.
okay,
Defective.
okay,
appeal.
thus this appeal is kept pending for the purpose of enabling the parties to cure the defects both before the learned trial court and the appellate court.
Lordship.
Upon necessary steps being taken before the learned trial court and the learned appellate court, the matter will be mentioned for further
Mark.
consideration.
Lordship.
For the-
It is however made clear that we have not gone into the merits and the parties will be entitled to take necessary steps by relying on the relevant provisions of law, both before the learned trial court and the appellate court.
Lordship.
ট্রায়াল কোর্টের কাছে
ট্রায়াল কোর্টের কাছেও একটা ডিফেন্ডেন্ট মারা গিয়েছে বলছে, যে ডিফেন্ডেন্ট মারা গিয়েছে ট্রায়াল কোর্টে সেই আবার অ্যাপেল কোর্টের রেসপন্ডেন্ট, ওখানে ট্রায়াল মানে
ট্রায়াল কোর্টে আর কি কারেকশন করে।
আচ্ছা তাহলে ট্রায়াল কোর্টে ছেড়ে দিই এনিওয়ে shall we I mean
The first appellate
Why
court, they will take the steps.
trial court has ordered as merged with the first appellate court?
No, that is true, but we are not sure that the defendant that has died, whether it has died before the pronouncement of the judgment of the trial court or not.
so
let
entire
them
thing
take
is
the
in
steps.
ambiguity.
Yes, Lordship.
Let them take the steps accordingly.
ওর প্রেয়ারে ওরম বলে দেবে স্যার দি লার্নেড অ্যাডভোকেট
Learned advocates for the parties are present. The matter is referred, the matter is put up for consideration in terms of order dated 28/11/2025 passed by learned coordinate bench of this court. Stop. In terms of the said order, learned advocates for the parties prays for leave to take steps before the learned trial court and the learned appellate court for curing the defects. তারপরে আমি যেটা বললাম
That would for the party, the appellant will do it.
Yes.
Lordship.
The appellant has to pay over that.
no whatever it is parties means whoever wants.
I'm grateful.
নেবেন কারেকশন
I appear for the respondent husband.
I'm appealing for the petitioner wife, Lordship. The settlement is, we're trying to settle the.
Outside court, the talk of settlement is going on between the parties.
ভেরি গুড কি
If it can be, my lord, adjourned for this, for some time, my lord. There was, my lord.
there is a possibility of settlement.
My lord, I'll
Next,
just
sir.
point out one thing. On the earlier occasion, a question was put to me by the honorable court that whether there is a chance of settlement or not. Now, my own instruction on that date, my lord, I had submitted that no, there is no chance of settlement. And thereafter, my lord, the order of a paper book was passed by the honorable court. Thereafter, my lord, the parties have decided to set for settlement.
No, we are recording that there is a scope of settlement of.
Yes, learned advocates for the parties are present. It is submitted by the learned advocates that talks of settlements are going on. In the facts and circumstances, the matter stands adjourned to enable the parties to arrive at a settlement. Let this matter be placed before the next circuit.
Grateful.
Number 8, yes. Admission on the order of 40 on the level. This is the admission. Admission on our water ruler civil, minor. This judgment of reversal. I just found the point of law and something of lawsuit issue. Then
You are defendant or plaintiff,
I'm the plaintiff appellant.
so suit was allowed, decreed.
Degree and appeal court. This
First appellate could dismiss the appeal. Very good.
I just, this is a point of law I have formulated, but if you was can see the point of law, I just, my lord,
What was the suit for, Mr.
I say, my lord. The original plaintiff was the father of the defendant eldest daughter. The father had two daughters,
Original plaintiff was the father of the,
defendant, defendant respondent, eldest, she the eldest sister. The original plaintiff having two daughters, one son. And the eldest daughter, the defendant, got married, then subsequently her husband passed away. She also decided Kuch Bihar. And both all of them decided as Kuch Bihar. The youngest daughter, she got married, but she was divorced. She decided with her father. Only son, he also decided with father. Father having a one house. The ground floor is tenant is the original state is what? The first floor, this half portion is tenant is the Grameen Bank. Half portion is a vacant, which is being used by the youngest daughter, who is a divorcee, for imparting tuition. And
the daughter of the original plaintiff.
yes, the two daughters, one this youngest daughter,
Original plaintiff is, what is his name?
Haripada Das.
So Horipada had two daughters,
2 daughters, 1 son.
2 daughters, 1 son. Very good.
Eldest daughter, the defendant in the suit, the eldest daughter,
Oh, eldest daughter is the defendant.
defendant. Eldest daughter got married and her husband subsequently passed away. She also resided at her matrimonial house in Kuchbehar.
Eldest. Eldest. And what about the
Young
son?
daughter got married,
Uh,
then she divorced. Now she used to stay with her father in the house and she is doing the tuition. And there's only 1 son.
Very good. Then what happened?
Now, the original plaintiff having a 1 house.
Portion of it is
But
presently
the ground
being.
floor is occupied by the tenant is the West Bengal State Electricity Board.
Hmm.
The first floor is the subject matter here. The first floor, half portion is occupied by
Hmm.
bank, half is a vacant, which is being used by his youngest daughter for imparting tuition.
Hmm.
They admitted. And the second floor.
Then what was the dispute? You said the eldest daughter is
Now
not
the
concerned. with the-
give deed, I'm coming. Give deed.
Oh.
So I'm coming. It's a very interesting point, my lord. Coming. And the first floor, the second top floor, the original plaintiff, his daughter, youngest daughter, and son and his family are residing.
So it is a 3-storied building.
Yes.
Very good.
Ground floor, first floor. This is admitted fact. And the eldest daughter, dependent, staying nearby in Kuchbehar.
Matrimonial house. Very good.
Then, my lord, what happened? The plaintiff's case, the original plaintiff's case is that he initially took loan from UCO Bank for his business. Then he could not pay the outstanding dues. His son and his wife managed to pay. He liquidated his
Entire loan amount.
Then he again took a loan of the UCO that now UCO Bank loan finished from the Grameen Bank who are in the first floor. So first floor, the original plaintiff took loan from the Grameen Bank by mortgaging his house property. This is my point. By mortgaging his housing property. My lord, the
Only mortgaging the entire property.
house property, the entire property,
Though first floor was given to Grameen Bank.
they have to
Very good. Mortgage.
mortgage.
Then what happened?
My lord, the plaintiff, the original plaintiff expressed a desire to execute a will and giving the main portion to his son and a portion to his youngest daughter and a small portion to his eldest daughter because she is studying in the matrimonial. This is a case of the original plaintiff, and he trusted on her eldest daughter for execution of the will. This is the case.
He made a will.
No, because in place of will, she made a gift deed in her name. This is the case. I'm coming back.
Oh, I see.
So this is a case of the original plaintiff. So he handed over all documents to his eldest daughter for execution of and registration of will. Then the case is that the daughter asked him to come at the registry office and instructed him to say yes in every documents. He trusted on his daughter, eldest daughter, went to the registry office and he put signatures. Subsequently, one Goswami, who is the attesting witness, came to take the rain on behalf of his daughter. Then, my lord, the original plaintiff inquired and found that a gift deed was executed.
So he preferred the suit for cancellation of the gift. Then what happened? Court dismissed the suit.
No, allowed.
Allowed the suit. I see.
So, because, my lord, the issue is that
Now, very good. Now, appellate court on
applicant
what
said-
ground said?
applicant say, no, burden lies on you to prove the original court, the civil judicial division, arrived at the findings that donee having the obligation, the burden lies on the donee to prove the genuineness and whether the deed was executed in good faith in terms of section 111 of the Indian Evidence Act.
So your case was
burden
undue influence.
Yes, yes. But this is a point. So the civil learned civil junior judge arrived
Single
at
just said burden is upon Dhoni.
Dhoni
Hmm.
in view of the section 111 of the Evidence Act.
Hmm.
And the
Actual evidence একটা বের করে দাও। হ্যাঁ, next.
and on the other hand, subsequently the language appellate court below arrived at the findings no. Onus lies on you to prove
Onus lies upon the donor.
Donor.
আচ্ছা।
Donor, that means who is challenging.
Who is challenging?
হ্যাঁ।
Donor has already gifted.
Yes, donor is
That is the plaintiff.
original plaintiff.
Plaintiff who is challenging.
By the way, he died, his son.
হ্যাঁ,
So, my-
donor-ই তো চ্যালেঞ্জ করছে। ওনার তো গিফটটা করে দিয়ে চলে গেল। এবার
How original? Only he challenged. He challenged.
মারা গেল।
এখন ওইটা
No, no.
তবে ওর ছেলেরা
Original, no. He original. Donor he himself challenged.
Oh, donor himself was challenged.
Donor himself
donor
challenged.
has challenged.
Donor is challenged. Donor is challenged that by undue influence.
Undue influence.
Did it.
Okay.
So, my lord, what I just formulate the point of law and see.
So according to you,
That's
section 111.
Yes. You got the book, I will give the book one. I
So
will got the-
he got you. Your contention is that this
Onus lies upon the daughter.
Dhoni, upon the Dhoni.
Don't need to put the daughter here to prove, because she was in an active confidence here because of relation. Freedom. This is a Supreme Court. also
That is
said.
the love and affection. This gift was made
No.
as per the document
Document.
by
yes.
love and affection, due to
But
love and
there's some also discrepancy in the recital also did. That I'll show, my lord. There's some discrepancy also. The first point is that
But the burden shifts only upon I have done my part, then it will shift to the
No,
Dhoni.
no. So
You're
I say-
arguing on
no,
that.
no, kind of 626, no, 111.
106.
111 first. I'm relying on the 111.
পেনটা তো শিফট করাতে হবে।
When there is a question as to the good faith of a transaction between the parties, one of whom stands to the other in a positive active confidence, the burden of proving the good faith of the transaction is on the party who is in a position of active confidence. My lord, there's a legal relations. My lord, I am covered by judgment of the Supreme Court also. I show it. My lord, here, my lord, this is an exception of the 106, my lord.
এবং তো অ্যাপ্লাই করে লিটারেট মোমেন্টাম থাকলে তখন দি পার্সন ইন কনফিডেন্সের উপর বলতে কনফিডেন্স প্লাস নিয়ার রিলেশনস এর উপরে নিয়ার রিলেশন যদি একটা আনডিউ ইনফ্লুয়েন্স করে তাহলে
He has to confidence. I saw given one second point of law, what is the active confidence? The extra active confidence, my lord, legal relationship.
কনফিডেন্সটা কনসিডার হয়
And just one judgment, my lord, this point, if you're lost, can allow me?
সুয়াস দি
অন্য কেউ হলে পরে কেসটা বহুত লুজ উইক হয়ে যেত, কিন্তু ডোনার নিজেই তো করে দিয়েছে।
I place the judgment, can I see judgment or paragraph 12? Paragraph 12, my lord.
Yeah.
As has been pointed out, the High Court that first appellate court totally ignored the relevant materials and recorded completely erroneous finding that there is no material regarding age of the execution when the document is questioned itself indicated the age. The court was dealing with a case where an old alien presented person was stated to the executed and no witness was examined to prove the execution of the deed of
ইস্যুটা
putting of the
এই যে told aging illiterate person. সেই জন্য 111টা পর্দানুসীন women হলে যেমন man of confidence.
Paragraph 30, man. Paragraph 30 is very relevant. In judging the validity of standard between the persons standing in a confidential relation to each other, it is very material to see whether the person conferring the benefit, on the other hand, competent and independent advice. The age or capacity of the person conferring the benefit and the nature of the benefit are very great importance in such cases. It is always obligatory for the donee and beneficiary under a document to prove due execution of document in accordance with law. Even divorce the reasonableness or otherwise of a transaction to avail of the benefit or claim rights on the document, irrespective of the fact whether such party is the dependent or plaintiff before the court.
So it is always upon the donee.
Donee, so you see the donee.
In judging the validity of the transaction,
yes.
standing in
But
the
the-
confidence.
My lord, my case is, my lord, she's the eldest daughter. She has a my lord, legal relationship is there. There's a fiduciary relation. So there's chance of undue influence.
No, all right, Mr. Law. Para 13 starts with what? That in judging validity of transactions between persons standing in confidential
Sir,
relation to each other. Next, it is very material to see whether the person conferring a benefit on the other had competent and independent advice, the age or capacity of the person
By the
conferring
years old.
and the nature of benefit are of great importance. So
Right.
it is not a case that
And
your donor was an illiterate person or he or she was some-
80 years. 80
Yeah.
years, my lord. My kind of secondly see,
Actually, apply করে।
it's 80 years.
Position-এ actual ডলি যেমন উনি ডলি ইনক্যাপাস মানে যে 7 বছরের নিচে না 4 বছর 6 বছরের তার যে অ্যাক্টিভ কনফিডেন্স তাকে যদি জেরা না করে আমি ডিগ্রি দিয়ে দিই দ্যাট ইজ ব্যাড কিন্তু এখানে তো বোথ আর লিটারেট পারসন
কিন্তু একটা ব্যাপার থেকে ডোনার নিজেই এসে চ্যালেঞ্জ করছে আর কি ডোনার যদি সত্যি মানে সুখ পেতে ভালো করে কোথাও চ্যালেঞ্জ আসতে হবে আর কি ডোনার নিজে কোথাও যদি পরের জেনারেশন বা অন্য কেউ কোথাও একটা ইয়ে দরকার
ডোনারকেই প্রমাণ করতে হবে দ্যাট ইজ এক্স্যাক্টলি হোয়াট দি ফার্স্ট অ্যাপিলেট কোর্ট হ্যাজ সেড
যে ডোনারকে
ডোনারকেই প্রমাণ করতে হবে ফার্স্ট অ্যাপিলেট কোর্ট বললো যে ডোনারকেই
ইয়েস ডোনার হ্যাজ টু প্রুভ
বার্ডেন ডোনার উপর থাকবে
Burden lies on the
that there is undue influence.
That is যেহেতু ডোনারকেই চ্যালেঞ্জ করে
যেহেতু 111 এখানে অ্যাপ্লাই না করলে তখন ডোনারকে ইয়ে করতে হবে বার্ডেন করতে 111 এখানে অ্যাপ্লাই করছে
অ্যাপ্লাই করবে জেনারেল প্রিন্সিপালটা কি যে যেটা আপনি বলছেন যে ডোনার যেহেতু সুটটা ফাইল করেছে ডোনারকেই এস্টাবলিশ করা উচিত
ডোনারকে
ফার্স্ট কোর্ট বললো যে না ডোনিকে করতে হবে কি কারণে করতে হবে হিমাস্টেশন এখানে এসে অ্যাপিল কোর্ট যেটা বলছে সেটাই সাপোর্টস ইওর প্রপোজিশন যেহেতু ইট ওয়াজ চ্যালেঞ্জ বাই দি
ডোনার হিমসেলফ
ডোনার হ্যাজ টু প্রুভ ইট
that there was undue influence.
কিন্তু ও বলছে যে না আমার বার্ডেন নেই ইট ইজ দি বার্ডেন অফ দি ডোনি ইন ভিউ অফ সেকশন 1.
But the donor has adduced any evidence to discharge that burden in the trial court.
নিশ্চয়ই করেছে সেটা নাও সেটা সাপোজ নাও যদি ডোনার এখন তো বলছে ওর আর্গুমেন্টে কি
No, total burden is upon the defendant.
ডোনি করেছে
the active confidence is there. She's a daughter. So eldest daughter, I have a lot of.
Mr. Roy, correct me if I'm wrong. In a situation where the donor himself has challenged the validity of a deed, is it not that the burden has to be upon the donor to
No, second, that also Calcutta has given the answer. What happened? Donor, the facts that donor is
to
active.
take us to that portion?
Yes.
Then confusion will be removed.
Yes. Can you find the facts? Can come the general analysis?
Yes, we have got it. Which paragraph you are wanting?
What is one?
The longest judgment.
Yeah, no. Can you some, if, here's the set of the facts, internal page 2, sir, internal page 2. he has put the trace of the painting in the numbers 2, 3, and
No.
4.
Reasoning.
Coming.
Yes.
And it was 2 to the place 5, he stated the case of painting. He stated the case of the dependent at page 7 and 8, and reasoning, my lord, has given either.
Page 7.
Yes. And coming, what the reasoning has been given, and coming.
This was a good judgment according to you.
Which one? Yes.
Trial court judgment.
Yes.
Because you are challenging the first appellate.
Yes. Findings were, yeah, sorry. And he also kindly come to.
What were the issues framed, Mr. Rai?
this-
Which paragraph?
I'm sorry. Yes, this is my lord. My lord. And internal 10, my lord.
Page.
Internal page 10. My lord.
Page 10.
Yes.
Yes, Mr. Issues. Maintainability, bad, necessity, preservation has an exclusive. ওই ইস্যুটাই তৈরি হয়নি এক্সক্লুসিভ টাইটেল now let us go through
And there's my findings.
issue number 5
So findings itself, if you also kindly.
They are issued the recast হলো আবার।
recast হলো
And yeah, recast it. And it has page, internal page 29, findings.
যা recast হয়ে কি বললো এতগুলো ঢোকালো সেখানে
But these are-
বার্ডেনের গল্পটা কোথায়
These are not most,
is the it false and fictitious এইটাই তাহলে 5 এর ইস্যু ডিসিশনটা
It
দেখি
No.
is liable to be cancelled being false and fictitious. Para 5. Issue number 5.
এটাই তো ইম্পর্টেন্ট where is issue
I
5
think-
decided
I can count internal page 29,
20
findings are. Got it, one?
Yes.
Paragraph 17, in the middle, law presumes primacy in favor of the deed being executed. The person who challenges the validity of the deed on the ground of fraud, misrepresentation, undue influence, charge, etc., has to discharge the burden of proof which lies on him. Section 111 of the Indian Evidence Act contains the exception of this general rule. The said section provides that where there is a question as to the good faith of a transaction between the parties, one who stands to the other in the position of the active confidence, the burden of proving the good faith of transaction is on the party who is in a position of active confidence. So if a relation of an active confidence or fiduciary relation subsists between the contracting parties, in such cases the persons in active confidence have to prove that the deed is genuine. There is no doubt that fiduciary relation exists between the father and daughter, where confidence is reposed by one in other, and that leads to a transaction in which there is a conflict of interest and duty of the person in whom confidence is reposed. Fiduciary relation immediately comes into existence. Once it comes into existence, it is for the person benefited by the transaction to show that the other party was at equal advantage, that nothing was concealed. The other party had disinterested advice and the transaction was fair. The original plaintiff contended in his claim that he had good faith and we are belief on the defendant as he used to consider as a woman with a broad heart who has professionally established herself. So he used to consult everything with the defendant. The defendant also stated in her witness statement that the original plaintiff used to visit her matrimonial home after the demise of her husband in order to console her and used to stay with her during due time and used to return in the house at night. So the original plaintiff used to spend a considerable tour every day at the house of the defendant. From these statements of both the parties, this court can get enough material to hold that a relationship of good faith and confidence used to exist between the original plaintiff and the defendant. So it was a burden of the defendant to prove the genuineness of the influence deed. In order to remove the presumption in favor of the original plaintiff, as per provision section 111 of the, she was supposed to convince the court either to the effect that the original plaintiff had disinterested advice or that the relation active confidence had ceased long before the date on which the improved transaction was made. This is judgment 19. The defendant reasonably failed to discharge her burden to prove the genuineness of property as she was required to as per section 11 of the Indian Act. Not only this, she also failed to prove her possession of the true property. Though she claimed that she had her parents school in a portion of the first floor of the school house, but she could not bring any document of her parents' school. To only tender the record rights in her name, and it can be seen that the entire first floor of the shoot house has been recorded in her name. But the document does not prove her particular position. She has an active deed in her basin which the record rights might have been recorded in her name. But really, it is not possible.
স্টোরি পাতাল
Most importantly, she did not produce the original deed of gift.
যে ডিসচার্জ করে দিয়েছে, যে এই আমার দলিল, এই আমার সই, রেজিস্ট্রেশন দিয়েছে, ডিসচার্জ করে দিলে সেই জন্য এবার পার্ডেন শিফট করে যায় যে ইট ইজ ইন জেনারেল।
ও তো পজিশন তদন্ত হ্যান্ড ওভার করে দিলে পজিশন দিয়ে দেয়, কনসিয়াসনেস যদি থাকে, কনসিয়াস পজিশন যখনই ডিট করলে কনসিয়াস পজিশন
Is delivery position? There is no delivery position. What is mortgage? Bank is there. See, most importantly, she did not produce the original deed of gift. The position of the defendant being the recipient there. Production of original deed of gift, the court from the trustee defendant would have a proof of accepted deed handing over the position of the suit property in her favor. But her failure to produce the original deed triggers that condition of the suit was not at all handed over to her and also cast a doubt as to whether the deed of gift has been acted upon or not. Trolling on the path of the above decision now, it can safely help that the original plaintiff successfully discharged his initial burden, but the defendant neither would prove the genuineness of the contents of the alleged deed, nor could remove the presumption under section 111 of the Evidence Act drawn in favor of plaintiff. She was reluctant enough to produce even the particular deed of gift, which could have helped her to prove at least the delivery of possession. She kept the deed up her spirit for which this court is compelled to draw adverse possession against the defendant as per section 114 of the Act. This is our findings, man. And now when you see the other things in the deed, there's some discrepancies that has also pointed out. And you can see.
Here you see, it's only a substantial question of law. If you admit, we have to formulate, not what evidence you adduced and.
No, this is, I'm showing it, madam. The deed, the inconsistency, in the deed also itself. I show my lord, if you can come to page 6, internal rules 5, that was recorded by the trial judgment.
Internal page 5 of the impugned order.
Yes, not in the first portion of the learned similar junior division order.
Page 5,
Internal,
yes,
I,
page 5,
internal page 5, I'm going.
yes, 5 of the judgment.
I. Statements made in the input deeds, you was got.
Yes,
Are not version of the original plaintiff, did not know Sanjay Das and Victor Bapa, the professional of defendant is mentioned in input deed as a guest wire sees the dancer and says a business grocery or garment. The original plaintiff was not a professional, but it was stated in the input deed. Apart from the address of the original plaintiff is also only stated in the input deed. And it's next, the wife of the original plaintiff has expressed in the year 2021. But in the input deed, written the defendant is still looking after her mother. In fact, since the marriage of defendant, she is looking after her relation, her children, and the original plaintiff under the care of the present plaintiff. It is also mentioned in the input deed that shoot property is gifted to the defendant so that she can reside along with her husband happily in her shoot property, which is absolutely false because her husband or the defendant has already expired. The possession should have not been transferred to defendant. Should property is not free from encumbrance. It is mortgaged by the bank. So it will not. It is false. But this is not a false. It was executed under influence. False I can't say. Because deed was executed. The execution of deed is made in a good faith or not, the donee has to prove the absence of undue influence or bona fide of execution of the deed. And my lord, the learned appellate court below, findings can you see? What simple say. I think appellate court below judgment, page 17, internal page 17. Therefore, considering above all facts and considering I am of the view that that would have hard shifting the owners of the dependent to prove a gift deed which is admitted by the
Page 5,
no, my lord, can he,
appellate court.
of the appellate court at page 17, internal page 17.
Yes.
Therefore, considering all the above facts and circumstances, I am the view that learned trial court has erred in shifting the onus upon the dependent applicant to prove the gift deed which is admitted by the original plaintiff by praying for cancel same and setting that it has been executed and registered fraudulently, and at the same time discussing and relying upon the content of said gift deed and deciding the case against the defendant. So judgment and decree passed by the requires inference, the same is liable to be set aside and is liable to succeed. The appellate court has not taken into consideration the scope and extent of the applicability of the section 111 in the present case.
Yes, appeal allowed and the suit dismissed.
Well, this is the findings. No, burden lies on the original claim.
Because you have pleaded fraud, Mr. Roy.
No.
You
Fraud,
have said alleged fraud.
but because this but fraud, undue influence, and coercion, these are all in the same
It has to
category.
be proved by you. You are the person who have executed the deed.
You also can see, this is language, this is kind of language. What did I say in the, my pleadings? My pleadings is
So
that.
your argument, if we have understood, is that the judgment was delivered being oblivious of the provision of section 111.
Yes.
In 111, it will shift to the person who is in active confidence.
The exception of section 106.
Say exception to 106. But in this case, your suit was that there had been coercion, fraud practiced. So
Coercion is there, coercion or
fraud
undue.
has been practiced. This is the
I see my language, but this is undue influence. Here, my lord, relation of daughter and
So if I say you have exercised undue influence upon
this
me,
is a scope.
I am going to court. I am saying that Mr. Roy has exercised undue influence against me. Will the courts ask you to prove? Court will ask me to prove that. Show your case.
Now the question is, even if there is undue influence, allegation by the plaintiff, if it comes under 111, mere allegation is sufficient that burden will shift under 111.
Yes.
Allegation of undue influence against the persons under section 111.
Doctor.
According to you, 111 is attractive.
Like I say, illustration.
Illustration.
Yes.
That is by the son.
The same thing is excess son. Let's see illustration B and 11. The good faith of a sale by a son has come to an age to a father. This question is suit brought by the son. The burden putting the good faith or conduction is on the father.
Right. Suit was by the son.
Son fights. God, this is vice versa.
Daughter has not filed saying that.
Here, my lord, sale deed, can see.
Son was of young age.
Young age. Son just come to age to a father is question by the son.
50 বছরের বাবা পজিশন অনেক বেশি শক্ত আর এখানে 80 বছরের লোক আর অল্প বয়সী মেয়ের পজিশনটা অনেকটা বেশি হবে 80 বছরের লোককে তো 30 বছরের মেয়ে করতে পারে আর এখানে 20 বছরের কি 19 বছরের ছেলেকে তার বাবাই কন্ট্রোল করতে পারলে তো বাবা ওই জায়গায় তো বাবার ক্ষমতাটা
But this is yes, no.
111, okay. Whether plaintiff has adduced evidence to establish that there was undue influence.
Well,
That is the second question.
trust. This is undue influence has come from the trust. The pleadings and the evidence of the original plaintiff is that he trusted on her, his eldest daughter. He has given all the documents to her daughter to execute a will and saying that one person will get the son, one person.
Yes, whether undue influence is proved by the plaintiff.
But no, plaintiff has not proved my lord. When is the
No,
relation?
no, that is a second issue. You see, 111, whether the learned trial appellate.
Relation. It's a relation and trust.
Mr. Roy, please answer my question.
There are two things. Suppose you don't succeed in 111. The burden shifts upon the plaintiff. Whether the plaintiff has been able to discharge the burden.
What's the plaintiff's case? Can you say what plaintiff has taken the evidence? He said, he deposed and he said, simple case. He said, I trusted my eldest daughter. I said him that he expressed desire to give a portion by will, one portion son, one portion youngest daughter, and some portion to the eldest daughter.
And those were there any evidence to prove that the contents of the deed were false? Entire contents were false?
Absolute discrepancies that are present.
Yes, that this person was not living.
Living.
This person.
Mother was not living, said that I'll look after my mother. This is that.
And it was not within the knowledge of both the persons?
Yes, mother.
It was within the knowledge of both the persons, but this false benefit, whether accrues any benefit to the donee or not.
Yes, sir. Donee said, I'm looking after my mother. Mother died long years back. He said, this gift was given for my to stay with my husband. Husband died. This address was given wrong. But in all the discrepancies are there. The unconscionable events are there.
No, in the plaint, so far the plaintiff is concerned, when he came to know, when he found the gift deed.
How he was pleading, my lord. His pleading is that, my lord, that he went to the registry office.
Yes.
Daughter instructed her to say yes to register, and he put the signatures.
Yes.
On 3 days back, one of the attesting witness, Pallav Goswami,
Yes.
is close to his eldest son. This is admitted. He came to him and said, I take this portion of rent from your daughter, the first floor.
Yes.
Immediately he told the other son and daughter, and then from inquiry they got the certified copy of the gift deed. And then he was stuck up, and then he filed the suit for cancel the gift deed. On the ground that was done, I asked him how to do it the will. He did it the gift deed. So when section 111, the trial judge.
After how many days from the date of execution of the gift deed?
Very few days. Within very few days, but this is reported by the court. My lord, if you can come to in the trial judge judgment, my lord, case under case 4.
Page 4.
Yes, of the judgment civil judge junior division. Internal case 4.
Page 4, yes.
Paragraph G, you got it? That registration of 3rd February 2024 exit of the registration. You got it, man? Now, my lord, on 17 April 2022, the original plaintiff met with the Kowal Goswami in front of the old stadium and field office. When Kowal is one of the attesting witness, he was not examined, and told him that he can get the possession of the passport of property as tenant to his daughter. Hearing this suspicious popped out in the mind of the original plaintiff, he told everything to the present plaintiffs. On 18 April 2022, the plaintiff could note taking the advantage of his good faith and believe that the defendant managed to obtain the income deed in his favor. The original plaintiff had no intention to transfer enforcement house in favor of the defendant or any other person because the inter house what is the mortgage for the Uttar 50 Bank. The question of transferring in question does not arise. But immediately he filed the suit. Immediately, madam.
So the original plaintiff, that is the donor.
The donor, the father.
কোর্টে সাবমিট করার অনেক মেরিট আছে, সব ভুল মানে যত সব ফলস এইসব করে টোরে এগুলোকে ইটটাকে বানিয়েছে অনেক রকম এগুলো এই যে ডিপটাকে চালু হয়েছে দুধের মধ্যে কে বেঁচে আছে কে বেঁচে নেই এগুলো সব মিথ্যা ইয়ে দিয়েছে এটা যেটা প্লেন্টিফের কেস ফলস ওয়েতে যদি ফ্রড প্লে করে থাকে তাহলে তো প্রমাণ তো প্লেন্টিফে করতে হবে প্লেন্টিফে প্রুফ দিয়েছে ও তো এভিডেন্স অ্যাডিউস করেছে এবং এই প্রপোজিশন অফ ল হলো whether the appellate court has rightly allowed the appeal on the proposition that the burden lies upon the donor, the burden lies upon the donor. Which is whether properly appreciated the proposition under 111 of এটাই হলো proposition of law.
I have up to the certificate.
কেসটা প্লেন্টিফের প্রুফ যথেষ্ট ভ্যালিড সব ডকুমেন্ট দিয়ে করেছে ও তো কিছু প্রমাণও করেছে
How many witnesses were examined
It was 4 witnesses.
from your side?
Myself, the original 20, son, 21, and 2 officers of the department. And they produced herself and her daughter, her son.
And defendant produced how many witnesses examined?
Herself and her son only. The attested witnesses have not come. This is section 68 of the evidence that will, I'm not going to this, I'm saying that burden only. But this is active confidence.
Attesting witness was not examined by the defendant.
She has not brought the original copy of the gift deed. The presumption goes against her. Secondly, she did not produce any attesting witness to prove the deed, genuineness of deed. But issue is not, the issue is that, my lord, that whether it is given a good faith or not, it is a confidential position, active brothers, father and daughter. It is admitted fact. They have a good relation. So, onus lies upon the shifted to the donee man. This is my point. And that has not been taken into consideration by the appellate court. Appellate court simply said, no, it cannot be shifted. No reason has been given. My lord said, you have made out the title, made out fraud. But you can see the fraud, fraud, undue influence, coercion, all are in the same pedestal. And there is a judgment of reversal, my lord. There is no question to stay because property is.
Who is taking the property now?
No, it is still in my position. Because one part is bank.
And where is the younger daughter staying?
Sitting with me after the
The top floor.
Yes.
Oh, all are deciding
Yeah.
that.
The original plaintiff, now the original plaintiff, son is family, and the youngest daughter divorcee, they are staying.
The elder daughter was the defendant.
Dependent, he has a matrimonial house and nearby the house in question. It's a Kuchbihar, both in the different part. The eldest daughter also lost her husband before this execution deed. And the plaintiff originally died. Now he was succeeded by his son, and youngest daughter.
And the entire property is gifted.
No, only first floor, not entire.
Okay, first floor.
The gift deed, the address gift deed relates to first floor. One of the portion is in the occupation of bank, half is vacant. Position has not been disturbed. It's still in the also in the.
করবে একটা চান্স নেই সুতটা যাই হোক একটা জায়গাতে তো সাকসেস hard on the following substantial questions of law. Whether the learned first appellate court are in law in setting aside the judgment delivered by the learned trial court. No. Whether the learned first appellate court substantially are in law in misinterpreting the extent of applicability of the provisions of Section 111 of the Indian Evidence Act, 1872. When the legal relationship between the original plaintiff stroke father and the defendant daughter was in existence as would be explicit from the pleadings and evidence. Next, whether the learned First Appellate Court failed to appreciate the evidence on record and the contention of the appellant that the initial burden stood discharged by the appellant. Next, whether the expression quote unquote in a position of active confidence embodied in Section 111 of the Indian Evidence Act, 1872. Would be applicable in a relationship between parties who are in fiduciary relation. Comma, as the father and the daughter in the case. As the father and the daughter. Stop. Suppose we formulated the other day issue. Let the hearing of the appeal be expedited. Lower court records be called for through special messenger at the cost of the appellant. Such cost shall be deposited within a week after the vacation.
7 days, Bhagwan, but
Within 2 weeks. Stop. No. Within a week after the vacation. This is closing down.
Yes.
Stop. Lower court records be called for within 2 weeks. Immediately upon arrival of the lower court records.
notice.
The office shall examine the same, and if found complete, shall issue notice of arrival of the lower court records to the learned advocates appearing for the appellants and the respondents. Next, the appellant is directed to prepare requisite number of informal paper books from out of court, within 4 weeks from the date of service of notice of the lower court records. Notice, very important date of service of notice of the lower court records, and to file the same after serving copies to the within 4 weeks on date of service of notice of arrival of local court records, তাই না? Arrival of local
Yeah.
court records.
But there's no
Stop
response.
all formalities regarding preparation of paper books are dispensed with. File informal paper books.
Informal paper books.
Have you filed any application? No,
Because
No execution.
no intention, nothing.
Yes.
With that. Yes.
চলো ডাকো।
Item number 9. Actually, item number 9, praying for hospital election.
ডেকে যাও।
এরপরে hearing.
10. My lord, after the appellant, my lord, I'm led by Mr. Milindu Pal. My lord, I'm praying for a next circuit since he has undergone an operation. My lord.
File to the item number 10.
10.
কি করবো? একজন করবো না, রেখে দেবো।
আমি চাইছি যখন নেক্সট সার্কিটের দরকার।
It was earlier.
My lord, since
What is happening,
my
sir?
lord-
Why do you want to keep the matters pending?
my lord, since I'm led by Mr. Milindu Pal here, my lord, he has gone through
As a second appeal, Argu, what is the, you are a young advocate. Have you gone through the file?
Yes,
So
my
there
lord.
was a direction to prepare paper books
I am
also.
aware of the facts of the case, my lord.
Huh?
However,
Admit it,
I'm on
There is
instructions, my lord.
paper books, informal paper books. There is a direction to prepare the paper
Oh, it
books.
is
also.
ordered for T1 now.
No. Same
Oh.
carrying of the appeal.
Suitটা কি ছিল? Have you filed the paperwork? Paperwork filed. Claim case.
Division bench or single bench? Railway claim case too. No, is it to be taken by the division bench or the single bench?
The division bench, my lord.
Because railway claim case is by the single bench.
It was initially, my lord, but now it is supposed to be taken up by the division bench.
No.
As per my knowledge and instruction.
Because railway claim case,
We have to check, my lord, if my lord's permit, we can check and come back.
this is ESI claim case.
Yes, my lord, come. Yes.
কারণ মোটর অ্যাক্সিডেন্ট ক্লেম কেস রেলওয়ে ক্লেম কেস সিঙ্গল বেঞ্চে হয় কিন্তু এটা
You are also praying, you are also not ready.
No, Lordship, I'm led by Mr. Arnav Sengupta.
You file on the joint prayer of the parties, the matter stands adjourned. Establish the matter for further consideration before the next available.
and ascertain whether it is to be taken by the division bench or single bench, otherwise it's
Take it out, চলো
So because of SCLC appropriate side.
Hmm.
My lord, the service is according to 15 capital A, the service of the victim is necessary, essential. My lord. So since the circuit is very short, the matter will be reaching by tomorrow or day after tomorrow, my lord. So can it be served to state? I have already served, but the service has not been effected yet.
Wait for today.
My lord, it can be served so that it can be taken up tomorrow or day after tomorrow. State can serve, state has the machinery. They can-
For that you have to, don't have to take my leave. That you can do. We are not recording any order to that effect. You want to
So I
serve that,
can request the state to.
that is your.
My lord, may I be allowed, my lord, to mention one matter? My lord, CRM number 869 of 2025. My lord, the matter was listed yesterday as item number 28. The matter was taken up by your lordship. My lord, during the course of my submission, my lord, your lordship was pleased to, my lord, have a query, my lord. He asked your lord, me, my lord, that whether, my lord, the charge sheet has been filed or not, as well as, my lord, the investigation is going on. My lord, inadvertently, my lord, mistaken of fact, my lord, I, my lord, make my submission that, my lord, the charge sheet has yet not been filed. My lord, investigation is going on. My lord, later on, my lord, I came to know, my lord, that the investigation has already been concluded and, my lord, charge sheet has been filed. And, my lord, your lordship, my lord, was pleased to, my lord, reject my lord, anticipatory bail application.
Yeah,
My lord,
in this charge sheet has been filed.
lordship. My lord, investigation has been completed. So, my lord, there is a new dimension, my lord, kindly.
What new dimension?
My lord,
What
charge
new
sheet,
dimension?
investigation has already been.
Surrender and take the bail.
My lord, kindly take up the matter, my lord.
I have
My lord,
rejected.
the state is there, my lord, state is there, my lord.
Very good, yes. I cannot rehear the matter. I have passed my order. You are saying that you omitted to mention that charge sheet
Lord.
has been filed. Charge sheet has been filed.
Lordship.
It will be there in the order.
My lord, so there is a, my lord, new dimension, my lord, arises in the, my lord, the case, my lord. As because there may not have, my lord, any custodial interrogation, my lord, requirement of any custodial
So I have
interrogation.
considered it on merits.
My lord, kindly, my
Of your
lord,
charge.
your
Sorry.
lordship.
Yes,
my lord.
call the list.
Item number 1.
I did a petition for bail cancellation, anticipatory bail cancellation, but the certificate copy I applied that not that report.
জেনে নাও না সুরজিৎ ডিপার্টমেন্টের সাথে কথা বলে নাও। কি বলছে? Stay out. You're for cancellation of bail. তো when কবে অর্ডার পাস হয়েছিল?
Passed by his honorable high
তা আপনি সার্টিফাইড কপি অ্যাপ্লাই করেননি? তাহলে সার্টিফাইড কপি তো লাগবে।
because I
তো দুদিনে তো পাবেন না, আপনি অ্যাপ্লাই করেছেন। হ্যাঁ,
this is the
সার্ভার কপি পেয়েছেন?
server copy.
দেখি দেখো। Is there any technicalities in the department as regards this cancellation? Certified copy attachment with the main matter?
It's not there, so that is a problem.
No, that we understand, but is there any such আর কোনো ইয়ে আছে ডিপার্টমেন্টের কোনো টেকনিক্যালিটি?
Relating to this matter, there are several matters. Some of the matters have been disposed of, some of the matters are pending. So, not only this is not the only matter. There are other matters also.
বিলটা মানে আগে একবার রিজেক্ট হয়েছিল আমরা অ্যালাউ করেছিল তারপরে আবার
চলে গেছে
চলে গেছে
সার্টিফাইড কপি ছাড়া ফাইল করতে হয়। এটা কি প্রিন্সিপাল বেঞ্চের মামলা?
না এখান থেকেই মাত্র কিন্তু ফাইলটা চলে গেছে প্রিন্সিপাল বেঞ্চ আমার ওখান থেকে বিদ্যুৎ ইস্যু করে এখান থেকে নিয়ে গেছে
সেটা তুমি জানো? তাহলে আমি লিভ দিয়ে দিচ্ছি। হ্যাঁ হ্যাঁ,
Well, it was CAD, I think, and the order was passed from the.
Oh,
The order
I
was
see.
CAD. And the record was taken, it was supposed to come back. In other matters also we have seen, the matters which are CAB has taken back principal bail, it's very difficult to get back the records. Even in one of my matters, I was for the state.
Leave granted. To file for the bureau. Yes, all the lists.
Yes, I am appealing on the state.
Milords, I beg to appear, Milords, for the complainant.
Milord,
Gas one.
Milords,
to
Shubham Ghosh.
Milords, before my Milords, I'm sorry. Milords, before my learned friend begins, Milords, may Your Lordship, I am audible?
Yes.
Yes.
Yes, what you are saying? এটা কি চলছে না?
Yes, Milords, before my
The problem
Milords,
is
before my
online.
learned friend begins, Milords, I just want
Yes, tell us.
Yes, Milords, there was a last order passed, Milords, and supplementary affidavit has been filed. Milords, I just wanted to point out, Milords, that supplementary affidavit is not in terms of the last order. Milords, I'll wait for my turn, Milords. I just wanted to point that out, Milords.
but these are the two. Not in the preceding circuit bench, this.
Yeah, just.
Yes, sir.
One and two. Have you served the supplementary?
Yes, sir.
What is the problem here?
Nothing is the problem, my lord. They had cited two judgments of the Honorable Kerala High Court and Andhra Pradesh High Court stating that in an anticipatory bail application, the applicant has to come himself. In this, my lord, the
He's authorized.
yes, my lord, they had cited those judgments. However, my lord, there is a judgment of our Honorable High Court in Bhubaneswar Datta. Bhubaneswar Datta, my lord, clears that entire doubt and says, my lord, the person can come himself or through his authorized representative. And in that regard, my lord, I had sought for a leave to file the supplementary affidavit. Now, my lord, the affirmation that is there in the anticipatory bail application is by the daughter of the my lord applicant. Daughter of the my lord applicant in item number 1, and my lord daughter as well as sister of the applicants in item number 2. So, my lord, family member, and there was only the lacuna that there was an authorization which was needed. That has my lord been filed through the supplementary affidavit that I've just placed before your lordship. So the lacuna therefore goes.
So what the court did the court decide the issue that
No, my lord, no. It was since they pointed out and we cited Bhubaneswar Datta's judgment, and the court said yes, Bhubaneswar Datta applies in this case. So you file a supplementary affidavit and do that correction. So, my lord, the supplementary affidavit has been filed. Now, my lord,
you have
now
objection to the supplementary affidavit?
Yes. Yes, Milords, may kindly take that for a minute. The supplementary affidavit, Milords, may kindly
Where
take
are
that.
those judgments which you are relying?
yes. But those perhaps
The
are
citations we shall.
Milords, I am not
Exactly.
quarreling. Milords, I am not quarreling on the proposition of law. My learned friend is
Then,
correct.
sir, why
that
don't
an
you
authorized
come and join
representative.
hearing here? Why don't you come and join hearing here? It is so difficult to hear you on video conferencing.
Milords, I apologize, Milords.
You are-
Actually, Milords, I
Are
am
you in
based in Delhi.
Calcutta?
Milords, I am based in Delhi, Milords.
By the time your submission reaches me, I have started hearing him. This is the problem with you. Not with you by the server.
I'm really sorry. I'm really sorry, Milords. My deepest apologies. Milords, kindly take the supplementary affidavit. I am not quarreling on the proposition of law.
Then what you are suggesting?
Yes, Milords, will kindly take the supplementary affidavit for a minute, Milords. It's a 2-page affidavit. What your lordship earlier directed is that there should be a statement in the affidavit that the person performing the application is authorized. Now, Milords, there is not a single statement in the supplementary affidavit to suggest that the earlier application and the affidavit was authorized. My lords will kindly see para 1. Your lordship has that?
I am authorized I am authorized
Milords,
to swear
he-
and sign.
to swear and sign this affidavit, Milords, not the earlier one. This affidavit,
Sir,
Milords, and my lords will.
if you do not dispute the proposition of law, why you are on technicality? Let us go into the merits.
Milords, I bow down to what is following, Milords, but it is important, Milords, because of two reasons. Milords, my primary two argument today for your lordship's consideration is one, there is huge amount of suppression in the original application that they filed. Number two, Milords, the petitioners, Milords, my humble submission is are absconding. To the best of my knowledge, Milords, they have not responded to 41 notices. Milords, and therefore it's important, Milords, your lordship will consider the last order and what the affidavit is. It's important, Milords, that's why I'm bringing this to your lordship's attention. Milords, and your lordship will kindly see the authority letter, Milords, they have annexed at page 5, Milords, of this affidavit.
What is the matter about? Antecedent connection with what? Dispute between family members?
No, my lord.
Then?
I'll tell your lordship what happened. My lord, the petitioners, along with the other accused persons who are on bail, but my first ground is parity, along with the other accused persons who are on bail, are, my lord, compositely partners of two partnership firms. And, my lord, these partnership firms are in the business of running a jewelry business. Now, my lord knows very well that from the year 2020, after COVID, my lord, the gold prices have risen up to, my lord, an exorbitant extent. Now, my lord, when that had happened, my lord, the big firms like the Tanishs and the Kalyans of the world, they, my lord, had exploding balance sheets. However, my lord, these relatively small-sized firms like ours.
Who was the complainant? Why don't go into the history? What was the
The complainant, my lord, lent us through our firms, my lord, a composite amount of rupees 85 lakhs as loan, as unsecured loan, on which we promised interest to them. We had paid interest to them 1 year. After that, we, my lord, defaulted. That is, my lord, the crux of the complaint.
Very good. Now,
my lord, they have brought up a story of a jewelry scheme. Now, my lord, this honorable court.
No, forget about that. Let us see what are the allegations against you and charge sheet file.
Not yet, my lord. Investigation is still in progress.
So you are the Sarita Sinhal is what? She's the proprietor of the firm.
She's a partner.
One of the partner of the partnership firm.
Partnership firm is name of the.
My lord, two partnership.
Yes.
Two partnership firms, my lord, Silver Queen Jewelers and Gold Diamond Silver Queen Jewelers. Kindly takes up the, my lord, FIR.
And who is the de facto complainant?
He's our customer. Now, my lord, we for our working capital.
So he paid 85 lakhs to you.
85 lakhs
for purchasing some.
No, my lord. It was taken as an unsecured loan. I'm showing your lordship the ledger.
Milords, that's where the difference in story is. Milords, I am not saying it's a loan. Milords, they have come up with this story that it's a loan.
Lord, these are the two ledger accounts.
Where is the agreement?
Lord, this was an oral agreement. And, my lord, we have paid them the interest on unsecured loan, on which they have, my lord, we have deducted the TDS and they have filed their income tax returns for 1 year. There is clear admission that the interest was paid to them. And they have filed their income tax returns on that amount. I have annexed all those documents.
Now, what about this dispute she is raising that daughter has come up on behalf of the mother and daughter is absconding?
No, my lord, daughter is
absconding.
Nobody is absconding.
Nobody is absconding, my lord. Yes, my lord. At this time, they are not arrested. Says that they are absent. They are not present in this film.
Where is she? Where is your affirming?
My lord, the daughter is not the accused.
We know that.
Yes.
Where is your daughter?
No,
she has come to court, na?
No, my lord. She affirmed the affidavit.
She affirmed the evidence.
Yes. She affirmed the affidavit on what he is saying is that the accused persons are absconding.
No, he is saying that the person has not been appropriately authorized because she herself is not in a place unknown to her.
No, my lord, that is not what he said.
That is what he said.
My lord,
that she is absconding.
My lord, she has affirmed the affidavit before the oath commissioner in the circuit bench. How can she be absconding?
I am not saying that. That is your friend's argument.
Yes, my lord. That is exactly what I am.
Where does she reside?
She resides in Pradhan Nagar, Siliguri.
But very good. She will come in court. What is your problem?
Yes,
my lord. Come in court on the date we will hear the application. Then your objection goes.
My lords, my objection is, my lords, she's filed this. My lords will kindly see the bail application.
No, I don't know what you make up your mind. What you are submitting. Your first submission was that this daughter has not been authorized and she is absconding according to you. That is why no authorization could be made. This is your story.
Milords, I'm sorry, Milords. I'm saying, Milords, the petitioners who are before your lordship, there are husband, wife, and the son. Milords, perhaps absconding because through the daughter. Milords, and they have now come through the daughter. The authority letter itself is dated 28th of November, and they filed this application in September, affirmed the affidavit in July. So, Milords, I asked myself the question, if the daughter is given an authority letter in November, how did she even file this application? Milords, there is not a single statement anywhere where she says that I have been authorized to affirm the affidavit in July and file it before your lordship's court in September. Because that's my submission for your lordship's consideration.
So then how does it help you to deny his claim for anticipatory bail? You are saying
Because
you are
that-
not disputing the proposition. You are saying dispute is as regards authorization or not. You are asking the court to a different aspect altogether, which is not the subject matter in this application. I don't follow what you are exactly arguing. I don't follow. You are disputing
Milords,
that
I'm
no
sorry,
such
Milords.
authorization could have been made. You are disputing that no such authorization could have been made in view of the sequence of dates given here. That is your contention.
Please, Milords, and Milords, there is not even a single statement by the daughter that she was authorized to file the application in September and affirm an affidavit in July, which is before your lordship. That's my submission, Milords, for your lordship's consideration.
She came, you mean to say when she came for authorization on 22nd July?
Yes, Milords. There is no statement that she was authorized by the petitioners to
Milord,
move this
can he take up that
application.
affidavit once?
Milords will
The
kindly see
evidence
the last
portion-
order. My lord will kindly see the last order. That will make it clear.
Let it be on Monday. I shall check up what is happening. I don't follow what is. Monday. Yes, next Monday.
Item number 3. I know the statement.
এই ফাইলটা একটু দিয়ে দিও। Yes, I do.
Milords, if your lordships permit,
Allegation under section Milord
I
380.
kept it on Monday, then you heard.
The allegation under the 384, 336, 342, 61.
And where is the junior? Where is the junior of the council? You get yourself ready in the matter. You get yourself ready in the matter and make your arguments on Monday. Whatever instruction you want, you take from your senior and you make the submission. Yes, sir.
Yes, Your Lord. The corresponding of 420, 463, 471 of the Indian Penal Code, Milord. Milord, the 35(3), Milord. All allegations below 7-year punishment is all below 7-year punishment.
একটু আমি আইপিসিটা আর ওই ডিএনএনএসটা বের করে দেন। এটাকে এইখানে আর এটা এইটা yes
318(2), Milord, is equal to Milord 420 of the IPC, Milord. 336(3) is equal to 463 of the IPC, Milord. 342 is the 471 IPC, and 120B is the Milord 61 is 120B, and 3 and 5 are 30.
all are bailable offenses.
Below 7-year punishment, Milord. 35(3) notice has not been could not.
No, all are magistrate tribal.
Yes, Your Lord. All sections below 7-year punishment, magistrate tribal case, Milord. 35(3) has not been served upon the petitioner, Milord. A petitioner
Where is the complaint?
Milord, kindly come to complaint. Page number 6. Milord, petitioner is not named in the FIR, Milord.
Yeah, just.
My lord, may I hand it over to CD? It is very
Yeah.
easiest to it.
Yes, what you are saying?
Lordship. My lord, you see the here and the CD lordship. These persons are became the owner, although they are not the owner, and they became the owner and consequently sold out to the third party.
This is not the first time incident, Lordships. This incident happened a month of your Lordship, August, and idea same type of offense in the pursuit of PS. Same type of, they are the habitual and they are doing all these things. And so far the question of that notice issue, their custodial interview is very much required. So that under that, and I talked with the IO said it's an organized crime. Some persons, official person may be involved, otherwise it is not possible to done all these things because first if the persons who died and he became the owner and subsequently sold to the third party. First from the CD itself, clear your
Just
loss.
So this Nikhil Orao became the owner after the death of his father, and Nikhil thereafter sold it to Neem Dorji. And what is then? I see. Oh, this is a complaint lodged by the additional sub-register.
Additional sub-register.
According to the guidelines. So this complaint has been treated as a FIR.
Yes. The petition is not named in the FIR.
Pardon?
Petition is not named in the
How can you be named? At that time, they do not know whether you had purchased or not. You are the purchaser from Neem Dorji.
No, I am not named in the, I don't know.
Have you purchased? Have you purchased? Where is the complaint?
And it's a P6, P1, P6.
Notices were served to all the persons associated with the deed.
But they didn't turn up.
So show us that notice was issued to him. Show us that notice was issued to the petitioner.
I allow me to meet the IO.
To meet the Maya, don't arrest. You want that, right?
Yes,
Let us see whether notice was given. Notice given.
But they didn't turn up. Well, notice given, I am not receiving any copy. Well, I have not received. They have, this is their documentation, Miller. Well, kindly see, Miller, whether I have received or not. No, you are avoiding to receive. Even I had been to your house several times.
Your signature is here, sir.
Why, Miller? But I am allowed.
Your signature is here.
Kindly, Miller, allow me to.
Abar bole kindly.
I have not received, Miller. I am not. I could have been.
How can the advocate be served? The client has been.
Yes, Your Lordship. No, I have been in the police, Miller.
Sorry.
Kindly, Miller. Even Lordship, it's a offense to the person sold the land of the other, became the owner, although they are not a owner. And they are prepare one power of attorney. Instead of that power of attorney, more person will be in the racket, Your Lordships. So at this juncture, if they got bail, Lordship, allow me to meet the IO, Miller. Magistrate tribal case, Miller. It may be Lordship adding. Every day, Miller, I will meet the Miller IO, Miller. Organized time, people, one may be added, Your Lordships. Any Miller, any condition. I will meet the IO every day, Miller. Any stringent condition, Miller. Magistrate tribal case.
So this power of attorney has been taken by this Nikhil Orao.
Nikhil Orao, Lordship.
And he is selling the property to seven.
Samyukta, Lordship, the power of attorney, Lordship. And the Lordship, another Lordship.
Just a moment. Now, just maybe I have a bit of silence in the courtroom. Yes. I see. Yes, what you are submitting?
Lordships, they are procured one power of attorney, state of that power of attorney, they sold to the party.
That is Nimdodji.
Name goes.
He sold it to various persons.
Various person. And the lordship, this is not the first time of this, your lordship. In the same area, your lordship, same jurisdiction, another case has been lost against this petitioner, lordship, Pashidar PS case number 293/25, dated 3rd July 25. And this case,
That
August,
case, I don't know, I don't have instruction.
Conduct of this
Apprehending arresting counsel.
Kindly allow me to meet the IO,
Sir.
Milord.
We have heard you, the learned advocate appearing for the petitioner submits that all the offences alleged, all the offences alleged are non-bailable and no notice under section. What is the new section? Huh? No notice under section 45(3) of 35(3) of BNS has been served upon the petitioner. Stop. He has been falsely implicated, and his name also does not feature in the complaint. In the said conspectus, custodial interrogation may not be necessary, and he would extend all cooperation to the investigating officer. Custody will not be necessary. Stop, Mr. Shortkar. Mr. Shortkar, an advocate appearing for this state, opposes the petitioner's prayer and submits that the complaint had been lodged by the additional district sub-register, Siliguri, Roman 3 at Ghoshpukur. And the Lord by one and the contents of the same would reveal that several transfers are being effected. Several transfers are being effected in a fraudulent manner. Stop. He further submits that investigation is still continuing, and though notice was served upon the petitioner, he did not meet with the though notice was served upon the petitioner on 6th August, this is 6th August, 6th August 2025, he has not met with the investigating officer. But this is Fasidawa case.
Outpost, main PS Fasidawa.
He further submits that the petitioner is also involved in another criminal case being Fasidawa case number 293/2025 dated 3rd July 2025 under section 318(4), 336(3), 342/3 of BNS, however. In the said BNS? In the said conspectus, In the said conspectus, the petitioner's prayer needs to be refused. Considering the learned advocates appearing for the respective parties, considering the nature of acquisitions, the petitioner's antecedent and the gravity of the offense, I am not inclined to exercise discretion in favor of the petitioner. Accordingly, the application is dismissed. Yes, next. Oh, hold on. Oh, it is the needs to be diffused. Shortcut last limited not his and in the said conspectus is applicable. More so when investigation is still conducted. Yes. Anticipatory or at this stage. Yes, next. Yes.
From the section 29, subsection 4, 118, subsection 109, subsection 1, subsection 5 of the Bharatiya Nyaya Samhita. So, there are these two regarding land and the date of incident.
So as the injury report, sir. You charge sheet submitted?
Submitted on 31st August 2025. No other exception.
Then why you are absconding? You also surrendered and obtained bail. All other accused are going.
Warrant issued against this petition.
Upon having heard the learned advocates and considering the materials on record, including the injury report, including the injury report, co-accused has been granted bail. Apprehending and Mr. Shatan Sir, an advocate appearing for the petitioner submits that that co-accused persons have already obtained bail. Submits that the petitioner submits that the petitioner has been falsely implicated. Stop. The other co-accused persons have already obtained bail, and investigation is also complete. In view thereof, custodial interrogation of the petitioner may not be necessary. Learned advocate for the state, however, opposes such prayer and submits and draws my attention to several documents in the case diary, including the injury report. Stop. Heard the learned advocates and for the respective parties, considering the nature of considering the injury report, the nature of accusations. Where is the warrant of arrest? Has been issued. Report submission and opposes the petition and submits that a warrant. Suppose that the petitioner is absconding and a warrant of arrest has already been issued. Taking into consideration the injury report, the nature of accusations, and the conduct of the petitioner, I am not inclined to exercise discretion in his favor. Accordingly, the application is dismissed. Yes, next.
The allegations are under section 64 of BNS, which is 376 of the Eastern Penal Code, and 351 of BNS, which is 507 of Indian Penal Code. Your lordship will get from the FIR that the petitioner is a married and a married lady who voluntarily and willfully went with the petitioner for a tour. That to lordship without informing her husband. They stayed few days.
Yeah, give me 2 minutes. But that is not the complaint. Complaint is a. এটা কত নম্বর item? Yes, Dilip.
My petition stayed.
I cannot read that.
A lady who is married, she went with the petitioner, stayed together for few days. Subsequently, her husband lodged a general diary. She got afraid, she came back and the FIR has been lodged. So my lord, whatever has been done in between that period when they stayed together, there might be the physical relation, my lord, occurred between them. That is completely, my lord, willful and my lord, voluntarily made by the between them. My lordship, I have, my lord, the affidavit of service which is duly effective. My submissions before your lordship that she is the married major lady knowing all the consequences she left with the petitioner without informing her husband. They
Was the 164?
that 164 said with the replica of the FIR because lordship the lady she is the complainant and she cannot recorded the part.
It's difficult for your lordship to read this.
No, what you are submitting is it is to be ascertained at the time of trial. What is was totally false. She was forced. She was forced to file that application on. Yeah, FIR itself. Where is the statement? That she has been forced to lodge the complaint by her husband. Then.
My submission is this, but she's a married lady.
Maybe you have said. Now, what is the complaint lodged by the lady has lodged the complaint? Now, what she has said, tell me. That she alleged that I went with the person and this happened, but it was not his consensual interaction, but it was forcible interaction.
And lordship this voluntarily done.
So, apprehension is 700. The advocate appearing for the petitioner submits that the petitioner is a married lady and has been implicated on the rudiments of unfounded allegations. Stop. There is no possibility that the petitioner would flee from justice, and in such circumstances. So, Dilip Kumar Bormon is the person who has come. You are the married lady with whom the married lady complained against Dilip. So, learned advocate appearing for the petitioner submits that the petitioner has been falsely implicated on the rudiments of a complaint lodged by a married lady. Stop. The relationship on the basis of a married lady. Stop. The records would reveal that the complainant himself admitted that they are known to that they are known to each other, that she knows the petitioner and their relationship. That you cannot say, madam, that will go against you.
Whatever I am submitting from FIR, it is clear she went with this person voluntarily stayed together.
Actually, the complainant voluntarily met with the petitioner and they even stayed overnight. In such sequence of facts, custodial interrogation of the petitioner may not be necessary. Mr. Sarkar, learned advocate appearing for the state, has opposed the petitioner's prayer and has drawn my attention to several documents in the case diary, including the statement recorded by the complainant under section, new section is 183 of BNS. Having heard the learned advocate and appearing for the reason considering the statement, considering the statement made by the complainant under section such and such, comma, the nature of accusations and the extent of complicity, I am not inclined to exercise discussion in favor of the petitioner. Accordingly, the application is dismissed. Yes. Yes. Monday. Yes, 6. 6.
Yes. Lord, I am for the petitioner. May it please your lordship.
Yes, tell us.
Yes. Lord, the case initially started not as a NDPS case. Lord, the police intercepted a vehicle. Lord, from that vehicle, fentanyls were recovered. Now, Lord, during investigation, Lord, the police, the investigating officer, sends the requisition to the manufacturing company of the fentanyl cough syrup as to which firms they have supplied the cough syrups with the batch numbers. So, Lord, from that reply of the company, manufacturing company, Lord, my name comes. Lord, I am a valid pharmaceutical business owner in the state of Bihar. Now, my lord, during investigation, police issues a section 94 notice to me asking certain details as to whom I have sold, how many quantity, what is the price, everything. And my lord, to that effect, I have even furnished a reply to the investigating officer. My lord, after that, another 94 notice, more or less similar 94 notice was given, and 179 BNSS notice to appear before the police as a witness. That I did not comply at that point in time. The second one. Thereafter, charge sheet was filed. My name did not find place in the charge sheet. But all of a sudden, thereafter, on 8th of January 2025, Milord, the IO files a petition before the learned trial court praying for issuance of warrant of arrest against me and another pharmaceutical firm businessman. Milord, thereafter, the warrant of arrest has been issued. Milord, now I am before your lordship, Milord, praying for anticipatory bail. Milord, the persons from whom the recovery was effected, Milord, they are on bail. Milord, the another person, Milord, against whom warrant of arrest was issued along with me, Milord, he was arrested. He has also been enlarged on bail by the
Go and take bail. Why anticipatory you are coming? Charge sheet file, appear, take the bail, say this
Milord,
is.
because I am not an accused person. I was never an accused person.
Your involvement is on the basis of the issue that you are a pharmaceutical registered firm.
Yes.
You have the capacity to do so.
Yes.
You have the jurisdiction to tell that to the learned judge. Why in anticipatory bail you are trying your luck?
Milord,
Suppose I do not exercise discretion in your favor. You will never get bail. Think over it, sir. What you are doing?
If Milord grants me that liberty,
Now,
Milord,
I will grant
now,
you
Milord,
liberty
since-
to go and file a
since
bail.
I am before your lordship, if lordship grants me liberty.
Don't move. Take it back. Take it back. Go and obtain regular bail.
Milord, if I am not granted regular bail there, Milord, at least I can go.
Then the court will be there.
Milord, kindly consider everyone is on bail, even the persons, Milord.
So I am saying that when everybody, why you are anticipating that you would be detained in custody? On the contrary, if I hold against you, they would be using this order against you in the bail. You will not get bail also then. Subject to what is your advice? Yes, sir.
Milord, let it be. If lordship grants me liberty to that effect, Milord, it could be with you.
How can I grant liberty in anticipatory?
Milord, may I take
Can
instruction?
in anticipatory, I will say go and liberty.
May I take instructions and come back tomorrow, Milord? One day for
About kiser
taking instructions from the client, Milord. Thank you.
What is, sir? You say, come and tell me. Come and ring up. Get it, sir.
Milord, in 10 minutes I am passed.
Yes, pass over. Next one. Same. Why? It is same matter. 7 is different. Who is for the petitioner in 7?
Dash was there, but he.
Pardon? You are there, Mr. Luxam. In 7? Monday, yes. Next 8. 8. Yes.
Lordship, the allegations are under section 85, 88, and 109 of BNS. Lordship, and for the husband of the de facto complainant, Lordship, this case is the counterblast of one case lost by one Unju Begum. Lordship, the counter case is at page number 13, Lordship. The actual fact of the case is that the de facto complainant fled away with the husband of that one Unju Begum on 11th of October. And thereafter, one missing diary was also lodged by this petitioner on 15th of October.
No, where you have stated that in your pleadings? What procedure? Where is the complaint?
Lordship, the main complaint is at page
That I cannot read.
10.
Who lost the gun?
This
One
is the de facto complaint. This is the wife of
Mafia Begum. Okay, Maficha Begum.
Mafija Begum.
Her husband is Manik Mia.
Yes, Lordship. This is the present petition.
Oh, so petitioner's wife
Petitioner's wife.
Lodged
Petitioner's wife fled
lodged a
away.
complaint against
Petitioner. Actual case is that I am the husband of this Mafija Begum. I am the petitioner. The Mafija Begum lodged FIR against me. But the actual fact is that
lodged a complaint against the husband.
husband and
What-
in-laws.
What allegation is?
85 and 88, section
Torture.
498, Lordship. Torture. Actually, Lordship, the
So
Mafija,
this is the complaint.
this is the complaint.
Very good. Now,
That
charge sheet submitted, madam.
no, investigation is going on.
Investigation is going on.
3rd November.
Acha, now very good. Then what
But
happened?
Mafija Begum, actually, she fled away with the husband of one Unju Begum.
Now she lodged the complaint
Then-
not only against her husband but also other in-laws. Yes.
She already fled away by 10th of October prior lodging this FIR. 10th October with the husband of Unju Begum. On that regard, Unju Begum has lodged and complaint. It is at page 12, Lordship.
So on 10th of October
10th
21st
October.
October, Manik fled away with Onju's husband. Manik.
Yes, no, Lordship. The de facto complaint, Mafija Begum.
Mafiza Begum lodged a
De facto
complaint
complaint.
on 10th.
On 10th October, she fled away with the husband of one Unju Begum. Unju Begum, at the first instance, lodged a complaint.
How do you get this complicated story?
Lordship, actually,
One
she fled away with another person
person's running away
to save
and
herself.
person's
Lodged a complaint against her own husband. Her own husband filed a
Just assist me, madam. What is this? Is a family problem? Huh? Do you know this Onju and what she said? I can't keep it in mind.
The complainant in this case, she fled away with someone else's husband. Then she lodged a complaint.
So
Because
Mafiza fled away earlier with somebody else.
somebody else.
Yes. And now
On
she
that regard, on
the
fifth-
what connection that has with this? What is the nexus of
I'm coming to the point. She fled away on 10th of October,
Mafiza?
Mafija. And on 15th
Now
October,
what is the name of Onju's husband?
Unju's husband.
That will make
That is
further complication.
Unju's Unju.
All right, then what happened now?
Lordship, I'm coming to the dates that will simplify the matter. The de facto complainant fled away on 10th of October, which reflects from the complaint of the Unju Begum, and on 15th of October, the husband, that is the petitioner, lodged a missing diary that her wife, that is the de facto complainant, is missing. This is not annexed there, but I have the copy of the missing diary.
And now when was this was
Thereafter, when the news spread that the de facto complainant is staying with someone else, then just to save herself, de facto
So why do you want anticipatory? Go and tell this to the police. Finished.
Lordship, I have told this, but my bail prayers was rejected. Might it not been agitated before the learned court below this point?
So the crux you are saying it is
Wait.
a false complaint. Ultimate
Lordship.
thing is a false complaint.
False complaint, just to save
Show us
herself.
any torture, any medical report, medical.
That lady was pregnant, she was beaten up by the petitioner, and there are statements of the neighbors of the accused, where they have stated that she was being tortured by the accused person. There are reflections on that.
But there must be some injury report.
Investigation is going on.
But where is the injury report, madam? Is it not here?
This is page 13, 14.
You check up, madam. I don't understand.
Lordship, the FIR was lodged on 3rd of November. Already by then she was staying with somebody else. I have lodged.
That allegation I cannot consider, na? With whom she, yes, what is the injury?
Husband.
Tell na, Mr. Chakraborty, any this.
The report is required, only the medical, that is the
Hospital
treatment.
Anything, any severe injury you found? But she's a pregnant lady yourself.
It's written up here.
Now she has been discharged.
That I'm not aware of.
So you bring that copy to me. Now where is she residing? She is at her maternal house, then paternal house, parents' house.
Parents.
And the other accused persons have obtained bail. You are the prime accused, no?
I did nothing, Lordship.
7th March 2026.
This advanced stage of pregnancy.
Yes.
She is not staying with me, Lordship. From the other FIRs, it is clear.
The story which you told me, where, in which paragraph have you written?
Paragraph number 4, Lordship.
Where is the order granting bail to the co-accused?
At page number 7 and 8.
So you bring the injury report then.
This sort of thing, I've already seen the very ticket, she has given medicines for abdominal pain and she was taken to the hospital and nausea medicines. And she was admitted on 9/10/25 Lordship. And I think after that she was released. Because if there was any injury report, I would have tagged it in the case diary.
We cannot go by that assumption, no? You come and tell me.
Try and get the. Otherwise,
Friday?
Tuesday, my lord.
Acha, Monday. Yes.
Great.
Next.
And it was a 9.
Yes. Oof.
The valuation under section 326, 341, 307, 354, 34 of Indian Penal Code, my lord. My lord, there was long-standing dispute between the parties. My lord, several occasions, my lord, settlement has taken place, my lord. But my lord, on 9/10/2025, my lord, when the husband of the de facto complainant was digging the land, my lord, this petitioner entered into the land and my lord, hot altercation took place and fighting occurred. Fighting occurred. My lord, out of 8, my lord, 6 has been granted anticipatory bail and 1 has been granted bail. 6 has been granted anticipatory.
This is the only person left out.
My, it's the only person charge sheet has already been submitted.
Anticipatory bail, sessions court.
My
Charge sheet submitted.
charge sheet
What you are showing, Mr. Chokku?
He is the principal accused. He is the person who had
24.
first hit both the injured person, both the victims, my lord, with a kodal, my lord. It is
My lord,
severe injuries. Both the injury reports are there, and once it's the 164 of the injured, my lord.
This is what you are showing?
And another eyewitness 164 is there.
my lord, he
যা যেদিকে আমার
Others persons, they are not so much related, my lord. That's why their bail were considered.
these are brothers fight between
They are brothers, and when there was a
and where is the injury report?
injuries, two injury reports are there. One is in page number 24, which is severe, and the one is in 27. 24 and 27. Both are head injuries, bleeding injuries, and severe injuries.
he himself got the injury.
He himself,
My lord, he was digging.
He himself
How it
beat
is
himself with kodal,
well, as he is the principal accused, otherwise,
apprehending arrest such and such. Such a learned advocate appearing submits that there was a fighting amongst two groups and the petitioner has been falsely implicated. The co-accused persons have already been, some of the co-accused persons have already been granted. Some co-accused persons have already been granted anticipatory bail. Investigation complete. And upon completion of investigation, charge sheet has also been filed. In such circumstances, custodial in detention of the petitioner may not be necessary. Mr. Chakraborty opposes the prayer of the petitioner and draws the attention of this court to the statement of the injured as well as made under section 80, 164,
183.
183 of BNSS. And the and also the injury reports. So considering the nature of acquisitions, the injury reports and the extent and that's considering the nature of accusations from the injury report and the extent of complicity of the petitioner in the alleged offense, I am not inclined to exercise discretion. in this matter.
Upon any condition, my lord, I will comply, my lord, kindly, my lord. Upon any condition, my lord, all other co-accused are on bail, my lord, kindly consider. My lord, kindly consider,
And
my
he
lord.
further submits that specific overt act will
Person, my lord.
Shruti?
My lord, he is an entirely person. Kindly consider, my lord, regularly I will comply with the investigating officer, my lord, kindly, my lord. Kindly, my lord. All other co-accused are on bail, my lord. Kindly consider, my lord. My lord, out of 8, 7 are on bail, my lord. Kindly consider, my lord.
Say this to the trial court and obtain the bail, madam. Yes.
But offense under section 498A 326 of the Indian Penal Code.
Who are you?
But I am the husband, but allegation is that about 5 years ago, marriage was took place between the parties. And after the marriage, you are subject to, there are allegations subject to mental and physical torture. But subsequently on 30th September 2025, an allegation is that the petitioner assaulted her with a lathi, and due to such assault, she had broken her legs. Thereafter, she was admitted to the hospital. But my specific instruction is that, but she fell down near well, who are fell down, and out of that, accidentally, her leg has broken out. And admittedly, there was a family dispute, matrimonial dispute between the parties, but the allegation of assault is absolutely false.
Yes.
Injury report, madam.
Grievous. Grievous.
Kindly see the statement before the doctor, my lord. Injured statement before the doctor.
There are several 161 statements.
What you're saying, where did you see severe?
Grievous, my lord. Last one. My lord. Extreme right.
This one?
Extreme right.
Oh, actually.
Grievous.
And there are statements,
Oh, there are several statements, my lord.
charge sheet submitted, charge sheet submitted.
Submitted. 4, page 4, 9, 10,
Charge sheet
22.
submitted, Mr. Go
What
and
that is, my kindly. Charge sheet, what
go
is
and
the
obtain bail.
necessary for my custodial interrogation? My charge sheet submitted, my lord. And my kindly see the statement from the
You
doctor.
cannot go away with the trouble, na? Had the injury report been otherwise, I could have understood.
My lord, kindly see the statement.
It is just that it is to go out of the trouble.
For my satisfaction, kindly see the statement before the doctor of the injured person.
Statement.
What she stated before the doctor, how she, my lord, sustained
Where
injury.
do we find it?
Page 26 to 30, the medical report.
How she's.
No, what Mr. Guho is submitting any statement recorded before the doctor, that is.
Don't see the university, man. Rather, it is clearly stated before, just before the report.
Appearing as present, Mr. Guho learned advocate appearing for the petitioner submits that the petitioner has been falsely implicated, alleging that he had tortured the complainant and caused severe injuries. But fact remains that the complainant fell down and her leg was injured and her leg was fractured.
Fracture.
Stop. And upon completion of investigation, charge sheet has also been submitted, and in such circumstances, and in the said conspectus, custodial interrogation may not be necessary. Mr. Learned advocate appearing for the state opposes the petitioner's prayer and draws my attention to several documents in the case study. Considering the nature of acquisitions, the injury report, and the extent of complicity of the petitioner in the alleged offence, I am not inclined to exercise discretion in this favor. Accordingly, application is dismissed. Yes, 11.
Lordship, I am for the petitioner.
Yes, sir.
Lordship, may I? Lordship, the crux of the case is that the present complaint was initiated solely on the basis of a confessional statement of the present petitioner in a separate case. Lordship, upon interrogation, the present petitioner allegedly confessed that he, along with the co-accused, has committed theft at several places and concealed the stolen items. Lordship, the FIR has been annexed, page number 7 and 8.
7. Who lodged the FIR? This is Suomoto.
Yes.
Say NDPS.
No,
No, Lordship.
Habitually dealing in stolen property.
Lordship, upon investigation, the
Investigation over.
Yes, 5-6 years back, 2019. Absconding since last 6 years.
Lordship, upon investigation, the stolen items were recovered solely from the premises of the co-accused. Now, the co-accused has already been enlarged on bail. Lordship, the charge sheet has been completed.
Then why are you so afraid to go to the court? 7 years you are out. Madam, you should advise your client to go and surrender. 2019 over.
Yes.
Lordship, the warrant of arrest was issued on.
So warrant of arrest was also issued, but you have not been
Sir,
declared a
the
proclaimed
in
offender.
apprehending arrest. Lordship,
Ashe, apprehending as present
Lordship.
application. Sorry, madam. Mr. Learned Advocate appearing for the petitioner submits.
Been enlarged on bail. Lordship, there was no recovery whatsoever from the premises or person
Go
belonging.
and obtain bail, madam.
Lordship,
Go
there
and-
is no recovery. Lordship, kindly appreciate.
How
the
this
fact.
conduct, how can be taken, tell us? I heard you, madam, but this conduct is not,
Lordship, there is
we cannot go beyond the particular.
Lordship, kindly appreciate. There is no. There
I
is
have
no
appreciated, that is
no
why.
corroborative evidence essentially linking the accused to the.
Miss.
Lordship, the petitioner will adhere to any condition. Lordship, kindly appreciate.
Applicant submits that the petitioner, Learned Advocate appearing for the petitioner submits that the petitioner has been falsely implicated on the rudiments of vague and unfounded allegations. Stop. The co-accused person, similarly situated with the petitioner, had already been granted bail. Upon completion of investigation, charge sheet has also been submitted, and as such, question of custodial detention may, and as such, custodial detention, interrogation may not be necessary. An advocate for the state opposes the petitioner's prayer and submits that upon completion of investigation, charge sheet was submitted in the year 2019. And the petitioner is still absconding. Warrant of arrest has also been issued. Having heard the learned advocates and considering the nature of acquisitions, the conduct of the petitioner, and the extent of his complicity in the alleged offence, I am not inclined to exercise discretion in his favor. Stop. Accordingly dismissed. Yes, next.
Item number 12.
Yes, madam.
Lordship, the allegation is under section 85 and 109 of BNS. I'm the husband of the.
85 is rape or
She's 498 corresponding to.
498. You are the husband.
I'm the husband.
Complain against husband and in-laws.
In-laws.
All granted bail.
In-laws are on bail.
So yes, show us some
Lordship, there are several.
charge sheet submitted.
It has not been.
Lordship, there are several talks of settlement setting for the reconciliation of marriage went over, but
When was the marriage? How many years?
marriage.
Within 2 years.
2 years. Lordship, I'm coming to the point. As per the allegation, last incident occurred on 16th of February, but the FIR lodged on 14th of October.
After 8 months.
8 months. In between that time, several attempts have been made for reconciliation of the marriage. It also reflects from the FIR itself, Lordship. And the matter also went before the legal service authority, Lordship. The husband still is willing to continue the marriage with the wife, but the wife is not willing to continue with this marriage. This is the actual crux of the case. Several attempts had been made and still he is willing.
Money from the wife. This is what. There are bank transactions on which the wife has given liquidate money to the husband. And if she's not giving the money, then again process will. I mean, thought it would be exactly.
There was no total 8 months delay.
Who like 10,000 gold? These has been given to gold jewelry, has been given first year minor.
Where are you reading?
Minor from the FIR itself.
FIR itself.
It's the allegation, Lord. It's only-
And from the bank transactions.
The husband is still willing to continue the marriage. For which
Pending
purpose?
the present application, learned advocate submits that the petitioner submits that the petitioner has been falsely implicated on the rudiments of vague allegations. Upon The other co-accused persons have already been granted bail, and in the said conspectus, custodial interrogation of the petitioner may not be necessary. Mr. Luxam, appearing for the state, submits that there are strong incriminating materials on record against the petitioner and investigation is still continuing. Investigation is still. আচ্ছা ওখানে ওই ভদ্রমহিলা আরেকটা লাইন দিয়ে না, the complaint has been lodged about 8 months after the alleged incident. After they have stop the such delay does not stand 8 months after the alleged incident. ওটা ওখানে ঢুকিয়ে দেবে। Upon heard the learned advocates of the respective stop considering the nature of acquisitions, the statements of the witnesses, the bank documents pertaining to transfer of money by the complainant to the petitioner and the extent of complicity of the petitioner in the alleged offense. I am not inclined to exercise discretion in his favor.
Transaction of money, there is no specification. The reason behind transaction of money, it can be caused for any reason. Lordship, legal service, Lordship, from the FI.
All right, I am deleting that line. Extent of complicity. Yes, next. 13, who is for the petitioner? Monday.
Fourteen after.
Lordship, had it been for Monday.
Monday it has been posted. Kept it on Monday. Yes.
14 after.
Monday. Yes, next. Earlier also you prayed.
Oh, Lordship, this is come.
These matters have been called for 3 days. If you are not interested, say that is otherwise.
This
It is not a newly appeared matter. It appeared for the last 3 days. Monday. Next. Yes, 16. Password. 17. Who is in 17?
Petition.
Yes. Who is opposing 17?
In this case, husband was arrested.
You are there, madam. Then
In this case, my lord, if your lordship kindly take the page number 10. Husband and father-in-law was arrested. And
who are you? Who are you?
I am the mother-in-law. Husband and father-in-law was arrested.
What? 498?
498 and 307.
Then why you moved the sessions court?
No, my lord.
You didn't go to the session court.
No, my lord. So, for my instruction is concerned, she did not move.
So show us the what is the allegation against you?
Page number 9, my lord. The allegation is omnibus in nature against the husband and the other-in-laws.
Yes, madam.
198A, 307, and 304, 4B of the.
Dowry provision, 3 and 4.
My lord, materials are there, so it's a report. That is the report, and allegations are that the complainant married with the former servant as per Hindu rights, but since after marriage, she has been tortured by her husband and in-laws, both mentally and physically. That is for husband is not employed, he and their family members always forced her to bring the money from her parental house. The complainant recently gave birth to a baby boy. That is the allegation, and those are reflected from the 161 statements.
But what is the allegation against mother-in-law?
Mother-in-law, lordship, pages number 8, 9 and 10, Lordship, of the neighbors.
Allegation is omnibus in nature, my lord. Husband is on bail.
8, 9 and 10.
The basic allegation is, my lord, at the time of negotiation of marriage, we have stated that he was working as a private.
She submitted.
No, my lord.
That she not submitted.
But subsequently she found I am unemployed. This is the basic allegation against the husband. And to make the case more serious, story of torture has been incorporated.
Acha, the lady did not give any 164?
No, my lord. Husband and father-in-law is on bail.
Are sir, don't repeat 10 times. I am not hard of hearing. Once you say, it goes in my head.
I may be excused.
Everything. Please excuse me because I am hearing you 10 times. Apprehending the Bhumik learned advocate appearing for the petitioner submits that the petitioner is the mother-in-law of the alleged of the de facto complainant. Incident after how many years? Marriage?
Not I am saying.
Do you have any issue?
My lord.
Have
Male
any-
child.
Huh?
Male child was there.
Oh. The de facto complainant. No specific overt act has been attributed to the petitioner. The other co-accused persons being the husband and the father-in-law of the de facto complainant had already been anticipatory bail, had already been enlarged on bail in the said conspectus, and as there is no possibility that the petitioner would flee from justice, custodial interrogation may not be necessary. Mr. Luksam, learned advocate, has placed before this court the statements of the accused persons along with the injury report and other documents. Having heard the learned advocates before the decision, considering the nature of acquisitions, the nature of acquisitions, the extent of complicity of the petitioner in the alleged offense. Consider nature of acquisition and the extent of complicity in the alleged offense. I am of the opinion that the petitioner's custodial interrogation may not be necessary, more so when it does not appear that there is any possibility that prima facie there is no possibility that she would flee from justice. Allow 10,000 to CODTs, 1 local, 482-3.
Grateful.
Yes.
My lord, item number 18, I may appear on behalf of the petitioner, my lord. My lord, I am paying for adjournment. May kindly fix the matter on Monday, my lord.
The allegations are.
Next circuit.
My
Yes.
lord, item number 18, I am appearing for the behalf of the petitioner, my lord. May kindly fix the matter on Monday.
Next circuit চলবে?
No, my lord. May
Monday
kindly mind.
next.
Grateful, my lord.
19 below time.
Item?
19.
Yes.
Lord, two petitioners. Lord, the story is of there was a free fight, my lord. The complainant sustained some injuries. I am told, my lord, that the nature of injuries are simple. Praying for anticipatory bail.
What was the complaint?
The
You are two
complaint says
persons,
yes.
Joydev and
Joydev, yes, ma'am. Joydev and shipping.
What is the relation between
Lord,
petitioners and the assaulted person?
Lord, both parties, these are rival parties, my lord. They have been contracted for, my lord, extracting the sand. So dispute between two rival parties were given contracts of sand extraction, and my lord, as a result, there was a free fight. There was a dispute, and my lord, the complainant sustained some injuries in that.
Yes, where is
Madam,
the
can you see
injury
the-
report? Charge sheet submitted?
Charge sheet,
Perhaps not.
well, it is not, yeah, charge sheet, not
Sure.
submitted, my lord.
So,
Kindly see the page number 8, 9, 10, the state 161,
Page 8,
8, 9, and 10.
where is the injury report?
Injury report 44, my lord.
8, 9, and 10. Complainant is Anil Varman.
Yes.
Yes, my lord. My lord, the complainant is Dhiraj Kumar Roy. Dhiraj Kumar Roy.
He died. Who was the victim? Who was the injured?
My lord, Dhiraj Kumar Roy.
Dhiraj's statement is not here.
No way. The statement page 8.
Page 8?
Yes.
Page 8 is Anil.
8.
আমি এবং ধীরাজ কুমার রায়
Then 9, my lord, 8. Independent. No. No, my lord, the statement is not there.
No, Dhiraj and this Anil was going together.
Yes.
Now Dhiraj's statement is not
No,
there.
Dhiraj sustained the injuries. Sir.
And the injury report you said page
44.
any specific statement that he lost? Why the injured statement is not there? Injured has not given 161. Have you checked up the
Yes, yes, sir. I checked, but I didn't find.
You have, when was the complaint lodged? Charge sheet?
My lord, 10th of October. Complaint lodged.
It is nothing. No statement of the victim, injury is simple. Charge sheet has not yet been filed.
Not yet.
Your presence was admitted. Allegation is against Joydev's allegation is there.
Yes, my lord. I'm not disputing that. However, my lord,
Then why should I give you anticipated?
on
You
any
can-
condition, my lord, I'll join the investigation. I'll cooperate with the investigation. My lord, like custodial interrogation may not be necessary. That is all I'm praying for. I'm not disputing that there was a free fire. I'm making a bona fide prayer.
that I can give to your wife, but why to you?
My lord,
Why
the
to
rival
you? She
party,
is a lady member.
my lord knows
Or
very well, my lord.
You go and surrender.
My lord, kind.
You go and surrender.
If the anticipated is granted, my lord, kindly grants it, both of them.
Charge sheet has not been
Not-
filed.
not
I don't
serve
know
any
English.
purpose.
I'm not getting the statement. Then I have to ask him to get the statement of the injured.
My lord, the nature of the injury is simple, my lord. I am entitled to.
You were previously admitted in another center wherein the injury was treated upon.
Okay.
Thereafter, you came to this government hospital.
My lord, that is their document. So if their
Injury
document
report says, doctor says.
yes, if the prosecutor.
You bring us, you give, tell me whether there is any statement made by the injured.
No, Your Honor.
What investigation you are conducting?
Actually, Your Honor, no investigation.
Then you
Process
talk
report
with
is
your
there.
investigating officer,
Just
sir.
kindly one, the accommodation is
Monday, yes.
Please.
20, yes.
My lord, I am appearing for the petitioner's court.
And for
My
the
lord,
state.
the FIR is drawn under section 126 subsection 2, section 78 subsection 2, section 107 subsection 2, section 109 of the BNS. My lord, the corresponding sections are 339, that is wrongful restraint, 354D stalking, 325 grievous hurt, and 307 that is attempt to murder.
Grievous hurt,
309, 307, that is attempt to murder.
yes.
Yes, may I take your lordship to page number 9, my lord?
How many persons are before us? 4.
No, my lord, 6. The petitioners are 4.
So 2 ladies.
2 ladies and, my lord, kindly appreciate the complaints who made, my lord. My lord, the
Page?
Page, my lord,
9.
9.
Yes, what you are saying?
Yes, my lord. My lord, the allegations are, my lord, the first informant alleges that one Debu Bormon used to stalk his daughter. Now on 30th October 2025, when his younger son was returning home at about 6 p.m. after playing cricket, said Debu Bormon and one Muhammad Joynur stopped him on road and beaten him up and caused injury in his hand by sharp weapon. Thereafter, his elder son came in to rescue, and his younger son, who was injured, was taken to a medical shop for first aid. Then again, the same Debu Bormon and Muhammad Joynur attacked him in the medical shop. And then he qualifies with a phrase that with an intention to kill him. And then his younger son, who was the victim, was taken to Siliguri District Hospital. Now, my lord, the petitioner, my lord, Debu Bormon and Muhammad Joynur are not before your lordship. My lord, the persons before your lordship are Dukhu Bormon, the father of Debu Bormon, Gauri Bormon, the mother of Debu Bormon, Bindia Bormon, brother-in-law of Debu Bormon, and the brother of Debu Bormon, Deba Bormon. Now, may I take your lordship to page 10 for a moment, my lord? My lord, in second paragraph, where they have stressed our complicity of the petitioners. Page 10 of the para second, my lord. Now they say that the father of the victim, when he went to the medical shop to inquire into the matter, these petitioners, that is the father of Debu Bormon, mother of Debu Bormon, brother of Debu Bormon, and sister-in-law of Debu Bormon, assaulted him. This is the only allegation against the present petitioners before your lordship. Now,
mother, brother, and father.
Father and sister-in-law. Although your that is their sister-in-law's reflection is not here in the complaint, but in the formal FIR, even the sister-in-law has been entangled. Kindly see at page 8.
Yes, Chachi submitted.
No, investigation is going.
Show us the injury reports.
The injury report.
We have there is no allegation that we have attacked the victim.
But though the type of injury says that simple injury, but the doctor Milord in the description has said that he has given 3 stitches to the person.
Now this Debu Burman is
Not before your lordship.
what he has. He has gone to the court below.
Yeah, he is also a minor.
Has he been arrested?
No, he applied for anticipatory bail. That was rejected by the learned sessions judge. Now he has been advised to surrender before the learned juvenile justice board because he is a minor. Both the victim and
Where from do we get that?
lordship kindly takes up the order of the learned district judge at page 16. The third paragraph, which starts from learned lawyer for the petitioner, firstly submitted that the application for anticipatory bail in respect to petitioner number 1. My lord has got it. My lord, it is nothing, my lord. A quarrel between 2 tender-aged boys in which the entire family got
Yes, sir.
entangled.
What do you say?
Milord, there are eyewitnesses, Milord, who have witnessed the incident. Milord, the entire incident has been captured in a CCTV footage as well. Milord, so these are the materials against them. But yes, they are the family members, Milord. The principal.
They are family. They are the petitioners are family members.
Of the
But the complainant is not a family member.
No, complainant is not a family member. These petitioners are the family members of the principal accused.
Right.
So
That
Milord,
is Debu.
Debu.
And what about that other person? This Mohammad Jainur?
Milord, he is also the principal accused, Milord. Similarly, Milord, both of them have
He
similar.
has not been arrested.
No. No.
So the allegation against them is pertaining to
Primarily
the
against them. As per the statement of the eyewitness. Nah, against the principal.
Principal accused.
Milord will find page 8 is the eyewitness statement.
Page
8.
it was. Who is Sujata Mahato? Sujit Mahato is not here. Sujit Mahato is here? No.
Ujit Mahato perhaps is the victim, my lord.
He is the victim.
Sumit Mahato is the victim. Sumit Mahato is maybe Sumit Mahato, my lord. Sumit Mahato is the victim.
Pending and disposition learned advocate for the petitioner submits that no specific overt act has been attributed to the petitioner in connection with an alleged dispute. In connection with the submits that there was a pre-fight between members of 2 families. This was there was no connection with the families. They were
Two children between the families, they got involved into a fight.
It submits that Mr. Advocate submits that no specific no specific overt act has been attributed to the petitioner's hearing pertaining to the dispute. Stop. The principal accused namely Debu Bormon, preferred an anticipatory bail application and by an order dated 10th November 2025, passed by the learned sessions judge. But after this, he went to High Court. After his bail was rejected, and
He has not moved the Honorable High Court. So far, my instruction is there. He has not moved the Honorable High Court. He has been advised, because my lord, he is also a minor, he has been advised to surrender before the judge.
No specific overt act has been attributed to the petitioners. Stop. The principal accused are one Debu Bormon and one Mohammad Jainur, as would be explicit from the complaint lodged. There is no possibility that the petitioners would also flee from justice in such circumstances. In such circumstances, custodial interrogation may not be necessary. The Honorable State has drawn opposes the petitioner's prayer and draws our attention to the statements of the witnesses and the injury report. Statements of the witnesses and the injury report. Hardly learned advocates appearing for the respective parties. Stop. Prima facie, it appears that the principal accused persons are Debu Bormon and Jainur Bormon.
Mohammad Jainur, my lord. Indulgence, my lord. Mohammad Jainur.
Mohammad Jainur. So they can stop. Stop. The complaint further reveals and that an omnibus allegation has been leveled against the petitioners here. Allegations have been leveled against the petitioners here. Stop. Insert. Stop. Considering the hardly learned. And that the allegations stop. Considering further the statement of the accused, considering the statement of the witnesses, the injury report and the extent of complicity of the petitioners in the alleged offense, I am of the opinion that custodial interrogation may not be, is not necessary. It's not necessary. Accordingly allowed with 4 persons, such and such, 482(3), with a further condition that the petitioner number 1 and the petitioner number 3. No, Debu Bormon is here.
No, Deva Bormon, that is his brother.
That is not Debu.
No. Can we see the FIR? At page 9.
Achha. Petitioner numbers 1 and 3 shall meet with the investigating officer once in a fortnight in investigations. Yes, next.
Much great. Grateful.
Number 21.
Monday, next.
Deeply.
21 OC.
Market.
About the statement.
Who is opposing him?
Mishra. What is Mishra?
Monday. Yes. এগুলোকে মানডে না এর পরে দিয়ে দেবো। Yes, next 20.
23.
You're the
petitioner.
Why? CD not there? Then Monday.
Tomorrow.
Tomorrow
I can.
Yes.
24. Tomorrow.
Monday we are. 24 same করে দাও।
25.
Why you are not doing and then let it go to the next circuit.
Station yesterday.
Not Monday, then
26.
Monday.
27.
Not today.
28.
How about the statement?
First time it has come.
Yes, no.
ডেকে যাও কি?
29.
I'm grateful.
30.
We ask for the statement on
31. 31 bill for Monday.
Next.
32. 33. 32. 33. 34. 35. 36. 37. 38. 39. 40.
What is happening, sir? Nobody is ready in matters. In these matters, who appears? Who are the counsels? Nobody is there in court.
No. What is the task? Steady.
None for the petitioners here. And I would be having no option but to dismiss these matters. What is the use of keeping there in the list running for so many days? ডেকে দাও, কালকে থেকে সব ডিসমিস করে দাও।
41.
For 41 and 42 plain. Item number 42, petitioner is already arrested, Lordship. And we are preferring there is an advocate change, Lordship, and we are
The learned advocate appearing for the petitioner submits that the you are appearing in this 42. একটু ফাইলটা দাও।
Lordship, in this matter, we are preparing a bail application, Lordship.
That is, this has become infructuous.
Lordship.
দেখি একটু 42. He has already been arrested.
Lordship.
The learned advocate appearing for the petitioner submits that the petitioner in the present case has already been arrested. Stop. In view thereof, the application for anticipatory bail has become infructuous and accordingly the same is dismissed. Yes. Yes, next.
44.
Actually, from 44 to 47, I'm paying for not. Matter number 6.
48. 49.
My lord, I'm for the petitioner, my lord.
Service complete.
By hand.
Hmm?
I have served through by hand, my lord.
এটা কি পাস হলো পড়ে গেছে? চারটে মতো
Yes, sir. May I please, Your Honor? My lord, the incorporating sections are 69, 89, 318, 2 and 3. My lord, the sections are sexual intercourse by employing deceitful means and miscarriage,
Yes, yes.
cheating. My lord, there is a huge gap in the age between age of the petitioner and the victim lady, my lord. And there was a long-standing love and affairs relationship in between the petitioner and the victim lady. And when the love and affair relation was breakdown, after that the written complaint was lodged, my lord.
I am appealing for the opposite party number 2, Lord. Copy has not been, I have informed the acknowledged defect of complaint, Lord. Sir, kindly allow me to have a copy of the petition. The matter can be fixed tomorrow.
আচ্ছা লেটেস্ট সি লেটেস্ট সি why you have come for anticipatory bail? Serious allegations against you.
My lord,
Allegation is that there was a long relationship, there was sexual relationship,
my lord.
and where you sought for money, she gave the money,
She gave the money and I have returned that money.
that is
my
the allegation. You're saying you have returned. Some portion has been returned.
Yes. Not
And
my lord.
when the loan has not been returned, now you're saying I will not marry you.
Not only that, she conceived one child.
She has conceived also.
There is no medical, my lord. There is no medical.
Medical.
So far the
So
instruction.
she has given birth or she is pregnant.
Mere allegation was there, my.
ultimately 164 statement is there, but medical legal examination is refused.
Medical
refused.
refused, my lord.
But 164 statement is there, specific allegation as per the written.
Investigation has completed, my lord.
Corroborate.
Investigation
Completed.
Yes.
Charge sheet has been filed. I'm the local resident, my lord.
Then go and surrender. Charge sheet has been filed.
And bank statement is there, Milord, he took the money and some money has to return to the de facto company.
Money has
The
been,
presumption will come.
my lord, money has been returned to the de facto complainant, and I have annexed a money receipt
7,68,000.
out of which 4 lakh was transferred through NEFT and 3 lakhs were transferred given by cash, my lord. And to that effect, I have submitted money receipt annexed D, my lord.
What is the age of the?
Lord, as per the record, the petitioner is 20 years and de facto company 31 years.
32.
31 years.
The girl.
That's late.
Victim.
Victim, my lord.
Victim.
My lord.
31 years.
But they are trying to,
Unmarried. Unmarried.
Not unmarried, my lord.
Yes.
She is married.
She is married.
Married.
No. As per
Where
our
did-
record, there is no whisper that she was married.
Where have you said married lady?
Unmarried, not unmarried.
Have you stated here?
Can you say?
No.
Ashok apprehending and present application has been prepared.
My lord, charge sheet has already been filed, my lord.
And she is using various resort and hotel, Milord, that is detected from the city.
She's
She went to the various resort and hotels for long time.
with this person.
Yes, Milord. This person took the lady to various hotel and resorts.
Yes.
My lord, she is not a minor, my lord. Whatever.
But promise is there. Promise of marriage is there.
Opinion present application. Affidavit of service has filed and kept on record.
I shall face the trial, my lord. I shall face the trial. I'm the local resident of the within the jurisdiction of the trial court, my lord.
To go and take a bail. Your sessions judge rejected your prayer.
My lord.
Go and
Anticipatory.
take bail. Allegations are not.
These are mere allegations, my lord.
Application is
And there is-
learned advocate appearing for the petitioner submits that a false complaint was lodged against the petitioner, alleging inter alia that he had committed sexual assault upon the victim on false promise of marriage. It has also been alleged that a sum of money which was handed over to the petitioner had not been was not refunded. Though what you are showing to me that though the
Annexed D, my lord, page number 34.
page number. What is this deed of sale?
Deed of sale. My lord, the de facto complainant has alleged that I have obtained her documents for marriage registration. But the fact is that the de facto complainant was preparing for purchasing a land. And to that effect, she had
transferred her documents to me. And I had managed lawyer and surveyor for their land registry, my lord.
No, this deed of sale is executed by whom?
Executed in favor of the de facto complainant, my lord,
By whom?
by the seller.
Oh, so she wanted to sell the property through you?
She wanted to purchase a property. For that reason, she had supplied some documents to me. And she had alleged in the FIR that she has supplied the documents, her identity card and bank passbooks to me to get registered the marriage. But the fact is something different, my lord.
So, as had not been returned, though the documents annexed to the petition would reveal that such allegation is absolutely unfounded. Upon completion of investigation, charge sheet has also been filed, and as such, custodial interrogation may not be necessary. The Bhattacharjee learned advocate appearing for the state opposes the petitioner's prayer and draws my attention to several documents in the case diary, including the statement of the complainant registered under section 183 of BNS. That is 183?
183.
Stop.
BNS.
Heard the learned advocates appearing for the respective parties. Considering the statement made by the complainant under section 183 of BNSS, the nature of acquisitions and the severity of the severity of the offense, and the extent of complicity of the petitioner, I am not inclined to exercise discretion in his favor. Accordingly, the application was dismissed.
Grateful.
I am grateful to your loss.
Yes.
But offense under section, my lord, 498A, 300.
আচ্ছা ওখানে একটা লাইন অ্যাড করে দিতে বলো। In that matter, investigation is over. In the earlier matter, he went away.
Yes, submitted on 31st October 2020.
Upon completion of investigation, or petitioneর বক্তব্যতে দিয়ে দেবে। On completion of investigation, charge sheet has also been submitted. Yes.
But offense under section, my lord, 498A, 302, 34 of the Indian Penal Code. My lord, this petitioner is the, my lord, non-die, my lord, brother-in-law, my lord. My lord, in this case, total.
Marriage was how many?
Yes, my lord. Marriage was solemnized on, my lord, 2nd of February 2022. But in this case, our allegation is that, my lord, after the marriage, the husband, namely Ujjwal Das, had inflicted torture upon her, both mentally and physically. Subsequently, my lord, on 15th of July 2025, my lord, this deceased was, my lord, forcefully, my lord, consumed poison by her husband, my lord. That is the allegation. Subsequently, he was admitted to the hospital. Subsequently, my lord, she expired. And total 5 persons are charge sheet has been submitted. Total 5 persons are charge sheeted. My lord, husband was arrested, subsequently granted bail by the learned court. And my lord,
other my lord, two accused person granted anticipatory bail by the learned session judge. And my lord, I am before your lordship. Husband is on bail, other co-accused person are on bail, but a charge sheet submitted. I am the non-die, I am deciding on a separate case. My lord, PM not done. My lord, yes, my lord, PM not done. But some medical documents are there, my lord. Shows that
Postmortem was not done.
not done, my lord. She was admitted in a private nursing home.
She was
And
taken
after-
away and burnt out.
Yes, madam. Yes, madam. Madam, the position is that, madam. The medical documents are here in the case diary. Shows that, madam, she was admitted on 18th of July. And case was initiated on 2nd of August. That means after her death. Discharge on 19/7. That means, my lord,
One day.
one day. She was admitted in the government hospital. Subsequently, she was treated in the private nursing home. Greenland.
Complaint was lodged on 2nd August. What is the allegation against this person? What do you feel? Omnibus allegation.
He is the husband of the sister-in-law, husband of the sister-in-law. And
Husband of the sister-in-law.
non-die. Yes.
And
And madam, in the from the medical report from the private nursing home, she was also discharged from the nursing home also. Admitted, but some days
after that she expired.
Yes.
Now, what was the allegation? Who administered the poison?
Her husband, Ujjwal Das. As per allegation,
Where do we
madam,
find?
But
Where
as
is
per-
the complaint?
but
Page 13. Where? Show us.
গত ইংরাজি 15/7/2025 তারিখে গভীর রাত্রিতে উপরোক্ত আসামিগণ মিলিতভাবে যুক্ত বুদ্ধি করে এক নম্বর আসামি কন্যার 2 পা ও 3 নম্বর আসামি কন্যার 2 হাত ধরিয়া আমার 1 নম্বর আসামি এগেন্স্ট মার্ট 1 নম্বর আসামি 1 নম্বর আসামি উজ্জ্বল দাস
And 3 number. Asami. That is you.
Madam, kindly see my
You are Ratan, na?
Yes, Ratan.
It is against you. বুদ্ধি করিয়া আমার কন্যাটির গায়ে মারিয়া ফেলার উদ্দেশ্যে
4-5 also, madam, they have granted anticipatory.
জাস্ট আ মোমেন্ট 2 নম্বর আসামি কন্যার 2 পা এবং 3 নয় কন্যার 2 হাত চাপিয়ে ধরে
4 নম্বর ও 5 নম্বর আসামি মুখ চাপিয়া হা করায় 4 আর 5 already granted anticipatory by the learned session judge.
Show us where is that order of anticipation.
But I have to produce tomorrow, but I have specific instruction granted anticipatory. It is also in the case memo of evidence in the case diary, madam.
Must be there that
Malad,
there is a specific act
yes,
upon
in the memo of evidence, madam, is there, madam, of the status of all the active persons. 4 or 5 also granted anticipatory. Well, kindly see. Last paragraph. 482. In the column box. Husband is on bail, my lord. 2 persons were arrested.
No, where is this?
Order is not.
No,
in the case diary.
I'm not saying this allegation. You said omnibus, but there is a
Madam,
specific.
in general allegation against all the persons, including the husband. Including the husband, all the persons.
No,
named
we are specific overt act. that
Yes, my lord.
He had caught hold of the hands and done it. Kindly come to the last 4 lines.
Yes, but 4 and 5 also, my lord, book chapia dhore haapar.
That we do not know. That
4 and 3, kindly see the FIR also.
cancellation will be moved by them. But why should I exercise discretion in your favor? In the
Because,
backdrop of this statement?
Because, but as per the allegation, madam, if all the accused persons are standing on the same footing.
No, that is not in the same footing. Complaint says otherwise. Complaint says 1 and 2, 3, 5.
No, 4 and 5 also. Independent witnesses are there in the Kindly see 4 and
We are
5.
not talking about the independent witness, we are talking about the complaint which was made after the death.
But complaint is not an eyewitness, my lord, first of all. Complaint is not an eyewitness. And second point, my lord, if your lordship go for the FIR, my lord, as per the FIR, my lord, every person is warned.
What
But
you are saying,
kindly
you
see the
are,
4 and 5.
what, that is your ground, you are saying 4 and 5 has
If
been
4 and
granted.
5 granted anticipatable by the learned session judge, but for your lordship, my lord, he is high court,
No,
my
no,
lord.
why should I accept? If that is a wrong order, why should I accept?
My lord, state did not file any cancellation till date.
That we will take necessary steps against the state. But how can you go away?
But kindly
Where
see
is the
my
charge sheet? Where
Malad.
is the charge sheet?
একটু দেখেন তা। Well, this complainant is not eyewitness. Or kindly see the other statement, my lord. Husband is on bail. Check করতে হবে। না ওটা ইসে তোমার বিল্ডলের হয়ে টাইম মাঝখানে কিছু আইটেম বিল্ডলের হয়ে টাইম কিছু বলবো ও 43 থেকে বলা 43 থেকে 49 হচ্ছে
You bring the anticipatory bail on Monday.
মালা এই চারটা খোলা
You also, Mr. Take
Malad.
instruction.
Instruction is there, Malad, in the CD.
No, no. Have you taken any steps or
Oh.
not on the basis of
Malad,
this?
Malad.
51. Who is your other side, Mr. Goon?
51, Malad. May I start?
Yes,
Sir, acting on a source information, Malad, police apprehended one Johurul Sheikh, as per the FIR. And from his possession, Malad,
তোর নামটা কি?
98 gram, আমার নাম হচ্ছে আব্দুল মাজিদ। No report.
আব্দুল মাজিদ।
But and from his possession, Malad, 98 gram of yaba tablet has been recovered. That is the FIR. And subsequently, Malad, during interrogation, Malad, my name has been transferred from the mouth of Malad Johurul Islam. Basically, I was implicated on the statement of the co-accused. Nothing has been recovered from my possession.
Show us the complaint. That is page 11.
But page 11 is the complaint, Malad.
Page 11. Johurul Sheikh.
Yes. Recovery from Johurul Sheikh. Not from me.
Yes, Mr.
But not from the co-accused, but from the independent local witness. And this is his role, my lord. His involvement is, allegation is about the cross-border drug transportation.
But that is statement of the co-accused.
No, not the co-accused. These are all independent witnesses of the locality. But I've underlined with pencil, my lord. Very difficult to read.
How can this, this is, suppose, how the pedestal differs? Independent witnesses also, it is statement of an
Co-accused and
independent person.
independent evidence. My lord, 161 statements are not substantive evidence. And the co-accused statement is not at all admissible in evidence. Unless there is a recovery from the statement of the accused or there is a confession confession not in terms of
But that can
161.
be
That's
ascertained
a
in
recorded.
trial.
That's a matter of trial. My lord, I just presented the evidence I had.
No, you tell us. You tell us. We can restrict his movement, but where is the direct nexus between the crime and the person? It was not recovered.
Except this
Except
statements,
this
I
here.
don't have anything to show. Statement?
Any antecedent?
No, not so far. I will check once. I will check the antecedent column.
What is your name? Abdul Majid.
Abdul Majid.
Apprehending and his present application, Mr. Guru.
Meet the investigator.
Submits that submits that the regards of section 37 of NTPS Act are not attracted since there was no recovery of contraband substance from the possession of the petitioner. Stop. His name transpired on the basis of Waku statement. In view thereof, the petitioner may, in view thereof, the petitioner may be, in view thereof, custodial interrogation, in view thereof, the petitioner may be granted bail, anticipatory bail on any condition. Mr. Learned Advocate appealing for the state has drawn the attention of this court. The statement of the witnesses and other documents in the case diary are the learned advocates of the responsible parties. Considering prima facie, it appears that no contraband substance was recovered from the petitioner, and his name transpired on the basis of Waku statement. In view thereof, the regards of section 937 are not attracted against the petitioner, and as such I am inclined to exercise discretion in his favor. Stop. However, his movement needs to be restricted since investigation has not yet been completed.
I think it has been completed. Madam, give me the state.
Take to the house.
Yes, my lord, completed. Investigation completed.
I word his movement.
Let him appear in the court on regular basis. And let him surrender within a stipulated time. Otherwise, he will never be, unless the witness appears before the court, the trial will not commence. And that benefit will be taken by the custody.
However, his movement needs to be restricted. More so when upon completion of investigation, charge sheet has been submitted. We were allowed 10,000 and 482.3 with a further condition. That
482.2.
Yes, it's 482.2 with a further condition that the petitioner shall attend the
Shall surrender, my lord, in a stipulated period of time. Otherwise, the trial will not commence.
Within 2 weeks.
And the custody, within the 2 weeks, let him surrender before the trial court and obtain regular bail.
Within 2 weeks, I surrender.
Then what is the use of granting anticipatory? I can say
No,
put arrest.
no, my lord, that is not the thing, my lord. And there can be two types of direction. One is the satisfaction of the arresting officer. In the event he is arrested, he shall be released upon such and such direction. Another can be, there are also, this type of directions are also common.
So you are saying that you grant him, we will not arrest him, let him go and surrender before the court below?
No, not that man. Not. My lord, as your lordship please. As your lordship please. I will not go into it.
No, the system, in certain cases, an anticipatory bail consideration order is passed that you go and surrender within such and such time, and till such time he shall not be arrested.
That is there, and it is also there that he will be in the event he surrenders, he will be even if there is a direction that he shall be arresting officer satisfaction, the surrender will be
I
taken.
am
by-
giving satisfaction arresting officer, I am directing he will reside within the locality of that place, and he will meet with the officer in charge on a particular period and shall also attend the court dates.
Enough, enough.
With further conditions that the petitioner shall reside at the address given in the cost title and shall meet with the officer in charge of Sahibganj police station once a fortnight until further orders. Stop. One order. With the this allowed. Trial has not commenced, charge sheet has been filed, charges have not been framed as yet.
Unless he appears on record before the trial court, my lord, the trial will not commence. That was my point. That is why I was concerned that.
No, why do you say so? Unless
if he is on anticipatory bail
Yes.
and he is not on record, my lord, he has not surrendered before the court or brought on record of the lower court. He has to appear before the lower court to face the trial, my lord. That was my point. There is another accused in custody, my lord.
he shall also attend the learned trial court on all the dates fixed for hearing.
Yes. And automatically he will go and surrender now.
আমি একটা কথা বলি। But in generally after granting anticipatory bail, my lord, all the accused surrender before the learning of the cell.
That is the procedure.
No, this direction of appearing at the trial in an anticipatory bail case, sometimes it may so happen that the charge sheet may be filed, but the charge could not be framed. Framing of charge sheet itself is a temporary order.
Yes, ma'am. If
Supreme Court says that you can tread into that path only upon framing of the charges. For that, the witnesses and everybody has to come. So while passing an anticipatory, it cannot be. Usually, it doesn't happen. You cannot have a notion that tomorrow the trial will begin or not. Maybe it's so for the discrepancies in framing of charges, the entire matter may get. So this direction becomes infructuous. Anyway, let it be. Now should next. Yes.
I'm praying for all.
Not this week. Yes. Not today.
Not
52 not today.
53.
I'm praying for one day accommodation in this.
Not today.
54.
দেখে যাও
55.
55 I'm praying for next week.
Then let it go to the next circuit.
My lord, the co-accused from whom the contrabands have been seized, her bail application is pending before this honorable court. I'm wanting to do this, my lord, after disposal of that bail application. So that should come up sometime in the next.
Co-accused here is.
My name transpires from her statement. Her bail application is regular bail application is pending before court number 3. So I'm wanting to do this after her bail disposal.
All right. Not this week.
Briefly, Your Worship.
My lord, I'm praying for a day's accommodation. Receive the case diary 30 minutes back.
Not today.
Kindly fix this matter on Monday.
Not this week.
50. 58.
Any matter where both sides are here? আচ্ছা এটা 60 অব্দি ডেকে দাও।
Matter on Monday.
Not this week.
No case diary.
59 not this week.
60 Monday lordship.
Not this week. Yes, Passover which matter?
There was one matter regarding that they must to surrender or not press the matter. Item number 6.
Yes, sir. What happened?
Blood will not move the appeal.
Acha, on the prayer of the
6.
item number
6.
on the prayer of the learned, no, the learned advocate appearing for the petitioner or petitioner submits upon instruction that the petitioner does not want to proceed with the present application. In view thereof, the application for anticipatory bail being such and such is dismissed for non-prosecution. No, dismissed as not pressed. Yes, any other Passover matter is there? 1/6.
1/6.
Who is your other side?
16 not handed over to me, but they have stated that I am holding the CD. I am not holding the CD and brief. So I sent my junior to check.
We fixed on tomorrow, Manu.
No, these will go on Monday. First,
My lord,
I
I am
have
ready.
called for 3 days.
I am ready, Manu. I am ready.
I sent my junior.
My lord, in the meantime, if I have been, this is a civil dispute, my lord. If I will be arrested in the meantime, that will be hardship for me.
Do you have the CD with you?
No, Lordship.
My lord, well, fix on tomorrow, my lord.
Mr. Bhomik, I would be keeping this next rider at the top tomorrow and day after. That was I was intending. And about relaxation also, those matters are lying pending whether I can take it up on one day or not.
Actually, my lord, so for the case is concerned, there is a civil dispute. And I am under pressure. And for that reason, I am subject to your lordship's convenience. If possible, day after tomorrow, my lord.
রেখে দিও ওটা তাহলে।
Day after.
ওইটাকে এই হেডে ঢুকিয়ে দিয়ে প্রথমে রেখে দিও। এই অ্যাপ্লিকেশন ফর অ্যান্টিসিপেটরি বিল এটা একটু নোট করে নাও নেক্সট।
Grateful, your lordship.
পাঠিয়ে দিয়েছি চেম্বারে, একটু চেম্বারে পাঠিয়ে দিও।
একটা